Ladies and gentlemen, good morning. The important things before starting is you need to confirm your presence for the tour tomorrow with the two options, Christ the Redeemer or Sugarloaf outside in the reception. Thank you. Welcome to the second day of the 2025 ICN Unilateral Conduct Workshop. Before starting the workshop, please put your cell phones on vibrate silent mode. Thank you for your attention. We will now start the plenary session, Remedies and Sanctions in the Unilateral Conduct. I have the pleasure to join the panel, the moderator, Mr. Diogo Thompson, Commissioner at CADE Brazil, Mr. Sérgio Sinovas, Head of Energy and Industry Unit at the Comisión Nacional de los Mercados y la Competencia, Spain, Ms. Katrina Kraup, the Chair of the 7th Decision Division at the Bundeskartellamt, Germany, Mr. Arturo David Aguilera, lawyer at the Antitrust Department at the Paraguayan National Competition Commission, and Ms. Naoko Teranishi, Director at the Japan Fair Trade Commission, will be with us remotely. Please, as you wish.
Good morning, everyone. Welcome again to the wonderful city of Rio de Janeiro. I'm Diogo, I'm Commissioner at CADE, and we start this discussion today on remedies and sanctions in unilateral contexts. When we talk about remedies and sanctions, we are dealing with the half of the battle. Finding anti-competitive behavior is only half the battle. The big question is what we do next. How do we stop the harmful conduct, fix the market, and make sure that doesn't happen again? That's where remedies and sanctions come in, and designing effective remedies, and it's easier than said and done. And that's why this discussion is so important. We have to ensure the remedy truly solves the problem without creating new ones. We have issues regarding monitoring compliance. This is a challenge in itself. Our remedy on the paper means little unless it's followed in practice. And we also have to get sanctions right. Fines need to be high enough to deter wrongdoing, but also fair and proportionate. So we must calibrate remedies and sanctions carefully. And also we have to think about how do we future-proof our interventions. That makes coordination and learning from each other crucial. And to solve this fascinating puzzle, which is not an easy one, and to help navigate these issues, we have a diverse and fantastic panel of experts around the world, and that's what we are trying to do here in this plenary session. So, without further ado, I want to start with initial remarks from our panelists. The panelists will have 5 minutes to do this initial remarks, then we have a Q&A session, and after that, a closing remarks. So to start, without further ado, I will ask Mr. Arturo David Aguilera. So Arturo, you have the floor.
Thank you, Diego. Good morning to all. Firstly, I'd like to thank ICN and CADE for the opportunity to be here. And I'd like to highlight how honored I am to be sharing this panel with these experts. I'm part of the Antitrust Division of the Paraguayan Competition Authority, which is a small agency that's been effectively working for less than 10 years. And I'd like to share a bit of our experience on sanctions and remedies. Just for context, Paraguay economy is a developing one, so it's common ground for dominant players to appear because of the market concentration and because of the reduced number of competitors, limited demand, etc. So when there's strong competitors, dominant competitors, the possibility of abuse of dominance is very real. However, CONECON, the agency I come from, has pursued relatively more lot cases related to anti-competitive agreements than those related to unilateral conducts. And that's partly because, as you know, investigations regarding unilateral conducts are hard, and require a lot of resources that most new agencies lack, not only in the quest for evidence, but also to access databases and also to process the collected information. That said, in 2023, and for the first time, CONECON sanctioned a firm for abuse of dominance, imposing a fine and also remedies as well, according to Article 9 of our competition law. The conduct occurred in the credit and debit cards processing market, and it involved a firm called Bancard, a company providing services of processing to most of the banking entities in Paraguay. And it was clearly a dominant player with a market share of over 80%. The investigation proved that Bancard had abused of its position, establishing exclusivity agreements with most of those banks in exchange of preferential rates to those banks agreeing with exclusivity, preventing them from working with another providers. Plus, Bancard terminated their service agreements with those banks who refused to sign the exclusivity, and were those banks, their complaint, the starting point to our investigation. CONECON concluded that Bancard abused of its position by limiting production and distribution, and also applying discriminatory treatment to equivalent services. The violation had direct effects, since it prevented most of the banks from considering their other competitors. So once it was possible to prove dominance, the traits of the abuse and the lack of justification of Bancard, CONECON took measures according to the extent of the harm to competition. It is known that sanctions are aimed to deter from the recurrence of the anti-competitive practice, while remedies focus on the restoring of the competition. And that's why such tools should be implemented according to the market situation after the practice, the anti-competitive practice. And its application must be proportional to avoid overly lenient remedies or remedies that exceed what is needed and limit competition. Paraguayan competition framework allows alternative or joint application of warnings, fines, corrective measures, and in the case of Bancard, CONECON decided or considered appropriate to impose a quite significant fine and a set of corrective measures of remedies. The fine was close to $1 million US, which is a huge fine for the standards of Paraguay. And while evaluating the amount of the fine, CONECON trying to balance the two criteria established in our competition law, not to surpass 150% of the income resulting from the practice, or the 20% of the gross turnover of the firm in the relevant market during the last year. So that, and also taking into account the relevance of the damage, the market share, market size, harm to competition, etc. On the corrective measure side, behavioral remedies were used aimed to restoring competition, such as cease of some conducts and ensuring no actor will be left off the payment network. And that's important because considering the traits of the market and the services, most players required to go through Bancar network to get their payment transactions processed independently of the processing company. I guess after that we will talk a little more about the remedies. Sir, thank you.
Thank you, Artur. Let's switch to Katarina, who will share with us the German experience.
Thank you. Can you hear me? Yeah, okay. Thank you very much, Diogo, and I would like to start also with expressing my real pleasure to be here at this workshop, which is so well organized, and it's with all those interesting panels. And I'm also very honored to be here and with my co-panelists, who are really experts in their field. And it's a real pleasure to be here. And I also would like to start that I'm going to express my personal views here and not the official position of the Bundeskartellamt. So I would like to start to explain a bit the framework we are working in when imposing remedies or sanctions for unilateral conduct in Germany and its specialties. Because I think for a lot of you or most of you or all of you, we all can address abusive behavior of dominant undertakings. And that's also true for Germany. We can do that based on Article 102 of the European Treaty and also based on Section 19 of the German Competition Act. However, in addition to that, in Germany, we can also address abusive behavior not only of dominant companies, but also if a company has so-called relative or superior market power, based on Section 20 of the German Competition Act. And this is the case, a company has relative or superior market power, according to German law, if other companies are dependent on them because there are no sufficient and reasonable possibilities for switching to alternative sources. Briefly. I mentioned this because all these provisions can not only be enforced by the Bundeskartellamt, the German competition authority, but also by civil actions of the harmed companies. And so remedies and orders to terminate abusive behavior might also be imposed by civil courts in Germany. And this actually happens a lot. Especially because of the special Section 20, which I mentioned, of the German Competition Act, because in those applying this section, this provision, the companies do not have to prove dominance of a company, but only superior market power. So this helps to foster civil litigation in Germany. Furthermore, we have a new provision in Germany which addresses abusive behavior of companies which have paramount significance across markets. This provision can only be, however, imposed by, applied by the Bundeskartellamt, and remedies can only be imposed by the Bundeskartellamt based on that provision. So now to what we can do or what we can be done if we suspect that a company is abusing its market power. We can also initiate administrative proceedings and fine proceedings. And administrative proceedings may be concluded, like for most of you, ordering that the abusive behavior should be terminated, and with cease and desist orders, or by ordering in a more detailed way what the company should do to alter its conduct in future. So, for example, we can order that APIs should be opened, that the company has to grant access to the infrastructure, that the company has to delete certain terms of services, certain clauses in the terms of services, or that a company has to offer products in an unbundled way, just to name some examples. However, the proceeding may also be concluded that customers may be reimbursed, especially for excessive pricing. However, that can only be done if you can identify the customers and also the amount of the harm. So it has been ordered already in Germany, but it's not very common. But of course, it's a nice remedy because then the customers profit of this remedy directly. In addition to that, we also have a provision that allows us to skim off the illegal profit made with the illegal behavior, the abusive behavior. But so far, we have not done that in the past because the standard of proof set by the courts to prove the illegal profit was so high that it was almost impossible to impose such a remedy. So, because you do not only have to prove the profit the company has made with illegal behavior, but also what would have been the profit without the illegal behavior. In this hypothetical scenario, the standard of proof we have to meet is so high that it is really difficult. However, this is why just recently the law was adapted because of this problem. Now we have an assumption in the law that the illegal profit amounts to 1% of the relevant turnover in Germany affected by the illegal behavior. This can be quite a lot, depending on the markets, of course. So we'll see, maybe we're going to go for this remedy in future. The relevant companies can offer also commitments to change the abusive behavior, and if they are sufficient, we can then terminate the proceeding with a commitment decision declaring the commitments as binding. I'll come back to that later. So, we can also simply, of course, conclude the proceeding without a formal decision. And not only this happens, for example, if the company changed its competitive behavior during the proceeding. Finally, I have to say in theory, we can also impose interim measures. However, we haven't done that so far, at least not in recent years, again, because also the standard of proof, which is imposed here for proving the imminent threat of serious harm to another company, which has to be proved if you want to impose interim measures. And so we felt that in most cases, it's maybe faster to go for the full investigation immediately than to impose interim measures in Germany. So as I already mentioned, we cannot only open administrative proceedings, but also fine proceedings. However, again, here, we only do that in very clear-cut cases because the courts often doubt that there was intent or that the companies really knew that their behavior was illegal. So in that cases, we cannot impose a fine. And so that is why we only impose fines in very clear-cut cases or in cases of recurrent abusive behavior. So to sum up, I had a look at the last 10 years and we had 13 proceedings where we found competition problems, and 3 were concluded by administrative orders, 4 by commitment decisions, 4 without a formal decision because the anti-competitive behavior was terminated by the company, and 2 with fining decisions. So you can find all those decisions on our website, by the way, on all those cases. Thank you very much.
Thank you, Catarina. Let's try to reach Mrs. Naoko. I think she's online with us for her initial remarks. Mrs. Naoko, okay. You have the floor.
Okay. Oh, thank you. Can you hear me?
Yes, yes.
Okay, great. So thank you, Diego. And first of all, on behalf of Japan Fair Trade Commission and myself, I would like to extend my sincere thanks to the conference organizer, Kazi, for organizing this wonderful workshop. And also thank you for allowing me to join this panel remotely. And it's a real pleasure for me to be on the panel. And in this initial remark, I will introduce types of remedies and sanctions in unilateral conduct in Japan, after briefly providing the overview of relevant Japanese legal framework. So first, our legal framework. In Japan, unilateral conduct is regulated by the Article 3 of the Anti-Monopoly Act, the Japanese competition law, which prohibits so-called private monopolization. And the Article 19 of the same act, which prohibits so-called unfair trade practices. So those are the two main pillars of regulation for unilateral conduct in Japan. And Article 3, private monopolization, is basically enforced by the Japan Fair Trade Commission, the JFTC, and Article 19, which is unfair trade practices, is enforced both through administrative procedures by the JFTC or through civil procedures, including injunction lawsuits. And from now, I will focus on the remedies and sanctions through administrative procedures by the JFTC. And basically, there are three types of procedures which include remedies against unilateral conduct. First are cease and desist orders by the JFTC, and second is commitment procedure, and third are closing an investigation with a voluntary measure offered by the party. And as to sanction private monopolization and certain types of unfair trade practices may be subject to a surcharge payment order. And as to the contents of remedies, remedies may be designed on a case-by-case basis to the extent allowed by the legal requirement for each procedure. For example, as to cease and desist orders, the Anti-Monopoly Act provides that the JFTC may order enterprises to take necessary measures to eliminate the violation. So this necessity for elimination of violation requirement needs to be met in case of cease and desist orders. And as to commitment procedures, legal requirement is that the remedies prepared by the party needs to be sufficient and expected to be reliably conducted. So, however, again, remedies can be designed on a case-by-case basis within those legal requirements, and I think it's quite important that remedies are tailored remedies are tailored to sufficiently recover the competition, considering all the relevant circumstances of the case. And remedies given by a cease and desist order or a commitment procedure generally include termination and non-repetition of the conduct in question, and notification of the remedies to relevant players, such as consumers and trading partners, establishment of a system to prevent recurrence, such as development of competition law compliance guidelines, and periodic reporting to the JFTC of the implementation. In case of closing of investigation with remedies, such voluntary remedies generally include termination of the conduct in question. And in some cases, specific measures may be included. For example, in the commitment case of Amazon Japan in 2020, where retrospective reduction of purchase prices and request for monetary provision to the suppliers by Amazon Japan were investigated on the suspicion of abuse of superior bargaining position, the approved remedies included payment by Amazon Japan to its suppliers of money to recover the disadvantages caused by the conduct in question. Another example is the commitment case of BMW Japan Corporation in 2021, where BMW Japan's conducts were investigated on suspicion of abuse of superior bargaining position against its dealers. And the remedies included establishment of an outside contact point for dealers to report suspected violation of Anti-Monopoly Act. For another example, in Osaka Gas case in 2020, Osaka Gas was suspected of unfairly excluding competitors by entering into a contract with customers that provided that the customer would incur a large amount of financial burden in the event of midterm termination of the contract with Osaka Gas. The remedy included revision of the relevant contract to reduce the amount of midterm cancellation fee. That's the basic introduction of remedies and sanctions in Japan, and I stop here. Thank you.
Thank you, Mrs. Naoko. And to close this opening round of initial remarks, I would invite my old friend, Sergio Sinovas. In my first ever ICN panel, we are together back in the medieval year, so it's a pleasure to have you here in Brazil. Sergio, you have the floor.
Thank you, Diego. First of all, I want to thank Kaji for organizing this event. Just almost 10 months after the annual conference took place in Salvador last year. And maybe you know, for a small authority like, or medium size like Kaji, is a tremendous effort to put this together with all the tenders, with all uncertainty, with the attendees, the panels. So I'm very happy, and thank you, Diogo. Also, I want to say thank you to the anonymous people working behind the scene to put this together, the different members of the working group. Alessandra Rosa, I think, is for here, but also colleagues from Spain, Juan Carlos, maybe I'm sure that they are watching us, but also Pitek Ibrahim from Turkey, and Daniel and Graeme from Swedish Competition Authority, who are not able to make it to come here, but without their work, this wouldn't be possible. So big applause for them. Thank you. So in Spain, we are able to set remedies in unilateral practices. We have different provisions, legal provisions, that enable us to, in exclusionary exploitative abuses, to put remedies. And once we have been very busy with this type of conducts, we are using more and more these legal provisions. So yeah, the Spanish Competition Act provides, they have some legal provisions. So we are able to put remedies structural, but also behavioral. Apart from that, the Spanish Public Procurement Act gives us the opportunity to impose a ban on public tenders or public procurement for these companies who are being involved in abuse of dominant cases. And this is another opportunity, another alternative that we are about to use it, to impose it in an exclusionary case. As I mentioned before, we have been very active in the recent years with abuse of dominant cases. The best example of this activeness in Spain is the booking case, our brand new case, booking case, with the highest fine in our history, with 413 million euros to booking, for different practices, both exploitative and exclusionary. And then, as a sum up, booking, we found out that booking was using its position in order to impose different terms, conditions in the contracts with the hotels, such as imposing a rate parity term, most favored nation term in the contracts, also imposing the duty for the hotels to use English, to use to Dutch law, and if any type of appeals referred to the Amsterdam Court, and also imposing a lack of transparency to the hotels in order to sign up for the different programs booking offered to the hotels. These were the exploitative abuses or practices, but also we found exclusionary ones. And these exclusionary practices in the booking case were related to imposing the number of bookings by the hotels in the platform in order to rank the results when a client is looking for a hotel in a place, and also using the performance score of hotels in order to remain in different programs that booking offered to the hotels. So we imposed the highest fine in our history, but also we imposed different remedies in order to seize all these different practices. So we are very happy that we are using more and more this legal possibility, and I'm sure that it would be the first big case where we have used this legal provision. As to the ban of public contracting is something we have used for the cartel sanctions, the decisions, but also we're about to impose this, as I mentioned before, in our one of the exclusionary case in energy markets. As you may know, Spanish Competition Authority is a big institution, including not just the competition authority, but also the energy regulators, energy, telecom, postal, transport. So it's very easy for us to detect potential abuses with information submitted by our colleagues. Also, every time they want to settle a conflict in the access of different networks, energy networks or telecom networks, the antitrust authority must submit a report stating that there is no problem from our perspective. And sometimes we detect a lot of potential infringements with these reports. And in one of these cases, the exclusionary case by Luminora, which is now on the table of our board, we are about to impose the first ban of public tender to this company, which was involved in abuse of dominance, excluding potential competitors in the access to the power transmission network. So yes, as I mentioned, we are very active with abuse of dominant cases and using more and more these legal provisions in order to seize the practices or impose some duties to the fine company.
Thank you, Sergio. Let's start our second part of this session, which is in a Q&A round. And I will start with Arturo. Arturo, based on Paraguay's enforcement experience, what lessons have been learned about monitoring and ensuring compliance with corrective measures in abuse of dominance?
Thank you. As Conacom, in the mentioned case, choose to apply behavioral remedies, we kept in mind that such remedies tend to require extensive monitoring. So the decision also established a schedule to compliance with the obligations. But as the ruling was almost immediately appealed by the sanction firm, they were granted an interim measure blocking us from enforcing the remedies. Conacom fought back, and even though the appeal is still pending, the interim measure was lifted, so officially we started monitoring the remedies after almost a year after they were issued. And it was, and it is still a challenge, because the sanction company is not really keen to cooperate with us, taking into account that we are still litigating about the case. So when we ask for information about the execution of the remedies, the responses are inconclusive, on and on. So we needed to amplify or request for information through the different players in the market, clients or competitors, in order to determine how one car was acting towards them. And we found out that to a certain extent, the company was complying with the remedies. About the lessons we learned in this path, and by evaluating the experience, we've learned that imposing remedies and relying on the information the sanction firm provides is not the best way to make sure that the remedies are really being implemented. So reinforcing the request for information directed to other players, we really believe that's the way. And in fact, in this case, once we started to check with competitors and clients, some concerns appeared about the possibility of the conduct still going on through different conducts from the violator. So it proved important to craft a wide range of inquiries. On the same path, this is a lesson and a reality. Our investigation team at the CONACOM is already surpassed by the amount of work. I mean, our antitrust division is currently integrated by 2 servants, including me. So if we combine the ongoing investigations with the monitoring of the remedies are almost entirely relegated. So when an agency imposes remedies that need to be seen as what is needed to restore competition, but also foreseeing what the agency would need for the follow-up.
Sergio, which are the main challenges you face when using remedies?
Thank you, Rio. Well, yesterday we had the opportunity to attend a very interesting session where we saw the main challenges the authorities are facing in Australia, New Zealand, Portugal, and Czech Republic. Was very, very useful. And we face similar challenges. It's not easy to set all the remedies right. Setting the scope, the right scope, the duration, deadlines of the remedies takes time in order not to make mistakes, severe mistakes that can be very harmful. Also, it's a challenge for us to monitor the remedies. I mean, the remedies must be fulfilled. Sometimes we make a decision, a remedy, we include a remedy in the decision, we forget the case, to be honest. So it's very useful to have a unit supervising, monitoring these remedies, because otherwise it's useless. They don't fulfill with the remedy. So it's very useful, and it's a challenge for us to take a look. And if the companies are fulfilling with both behavioral, sometimes structural types of remedies. In Spain also we have a big challenge with our judicial review. We have 2 instances. First, the Court of Appeal, the Spanish Court of Appeal, the Audiencia Nacional, and then the Supreme Court. But it's a huge pipeline in the review, and can take 8 years till the final decision is confirmed, upheld by the Supreme, if we are lucky. So during this time, most of the companies, dominant companies, they ask for interim measures, and most of cases, these interim measures are granted by the judge. So during this long period of time, 8 years, 7, 8 years, they are not fulfilling, there's not a duty to fulfill with these remedies. So we could say that in a way these remedies are not proving useful. They're not useful to solve the situation in the market. Sometimes what then happens, we try to be against these interim measures, but our courts are granting always. So something we're trying to change, but it takes time. And also, yeah, this is one of the main challenges. You have to know the market very well to set the right remedy, the context, and not make mistakes in the way that sometimes where we're not thinking on some topic to be aware of in the remedy, and then this little mistake or little failure in designing the remedy, it's very important, and then make the remedy useless. So these are the main challenges we face when setting the remedies. Set the right scope, monitor the remedy, and then what happens after that with the judicial review.
Thank you. Thank you, Sergio. Let's switch a little bit our subject here for the types and then the effectiveness of remedies. So, Katarina, from the German legal perspective, how do you assess the effectiveness of structural versus behavior remedies in cases of unilateral conduct? I know it's tricky sometimes to define whether it's a structural or a behavioral remedies, but I want to hear from you.
Thank you. Well, in merger cases, my answer would be clear. Structural remedies and particularly divestitures are mostly the only remedies that are accepted by the Bundeskartellamt, which is also appropriate because the merger is a structural change. However, unilateral conduct is a behavior, and most of the time, and with respect to abusive behavior of companies with market power, it is explicitly stated in German law that structural remedies may be imposed only if there is no behavioral remedy which would be equally effective. So it's kind of the other way around. And so this is due to the principle of proportionality. So I don't want to say that divestitures are not a good measure at all. Especially, I mean, now there are some cases on the table. I think of the European Commission, the attack case, and the DOJ, which where divestitures might be even the right measures to address the competitive problems in an effective way. However, in Germany, we have never imposed a divestiture so far as a remedy in unilateral conduct cases. But as you said, it's a question, what is a behavioral, what is a structural remedy? So like we do impose remedies like opening up of APIs or giving access to infrastructure, or Chinese walls might be something that you can impose, and we also do impose such remedies. So you might consider those as structural, yeah. However, I haven't answered really the question yet, which was which are more effective, which remedies. The thing is, again, of course, we heard this again and again already today. I think there is no general answer because it depends on the cases. And unilateral conduct cases are complex and individual, and therefore there is no really one-fits-all approach to stop abusive behavior. So at the end of the day, you have to make sure imposing remedies that you somehow can monitor the compliance in future with your limited resources. We all have limited resources, and in some cases, simple cease and desist order is enough. Maybe combined with obligations to report by the affected company. Or if market participants will notice and will complain to you if there is non-compliance, and maybe just set up somehow a framework where they can complain to you, or a monitoring trustee. And if non-compliance is obvious, high sanctions might be also already a deterrent factor that will make sure that the company will comply with your orders. So if they do not comply with them, So that might be, in some cases, simply enough. However, in other cases, where monitoring of the behavior is not that easy over the years, you better look out for a remedy. You have to be somehow creative. That maybe, for example, has to be implemented within short time with hopefully a long-lasting effect. So if you call that a structural remedy, for example, the opening up of an API or combined with reports by the affected company to the competition authority, sometimes also with the assistance of a monitoring trustee, which might be very helpful, especially if you do not have special know-how, for example, concerning APIs, whether they're really opened up in a non-discriminatory way. That's difficult to assess for lawyers and economists, so it's better to have somebody there to assist you to try to find out whether this is really, the remedy was really fulfilled. So those are, I think, the measures you can take and you should go for if it's too difficult otherwise to monitor over the years whether there was compliant behavior if you just order to stop it.
Thank you, Catarina. Still in this topic, Sergio, could you share with us what solutions you have found in the challenges that you mentioned before?
Yeah, thank you, Diego. As I mentioned before, we face different challenges, and we made up different creative solutions to deal with it. In order to set remedy right, it's very useful and important guidelines. I want to thank publicly to my colleagues of the European Commission because their guidelines, exclusionary guidelines, are very useful, for our authorities to understand potential theories of harm and also to impose the right remedy. Also, we are being busy with this type of guidelines, submitting a public guidance for the ban on public tenders. We published this guideline and it gave legal certainty to the parties as to the extent of this potential remedy could be imposed in our unilateral decisions. Also, it's very useful to test these remedies before imposing the remedy. We used to test with the market. We used to ask the competitors, the clients, pros and cons of this wording. Sometimes they gave us very sensitive and important feedback in order to amend the wording and to include some aspects we were not in consideration, we don't not having in consideration. For us, it's always a successful story, our monitoring unit. They are very busy monitoring the remedies we impose, both in mergers, but also in unilateral conducts. And it's also very important not just to monitor, but also to give us the instructing units how to impose the remedy, what type of remedy, what happened with former cases where we imposed similar remedies, if they were useful or not. And they gave us very important tips, and it's very useful. In cases where they see that they are not fulfilling with the remedy, they are even able to open a sanctioning proceeding. And also they are being very, very busy with these sanctioning proceedings, imposing fines, 5 million euros, 10 million euros to this company that after a while they are not submitting information to check if they are fulfilling or not, or even making the divestitures, it was compel or ceasing orders in order to stop exclusionary exploitative abuses. So it's very useful, and we have seen that once we open these proceedings, the companies in the sector, in the markets, they are taking more seriously these remedies, and it's very useful to have this monitoring unit to deal with the cases. So guidelines, testing, monitoring units, and sanctions in case they don't fulfill are solutions quite easy to implement and very, very successful in a way.
Thank you. And I think another topic that is interesting to cover is how we as authorities choose amongst commitment decisions and corrective measures, and how do we manage to do that. So I would ask Arturo, based on the first conviction of the abuse of dominance in Paraguay, what corrective measures are imposed and how do they compare with other remedial approaches?
Thank you. Paraguayan competition law contains a fairly general, non-exhaustive set of remedies, such as cease of conduct, actions in order to restore competition, actions to exclude the anti-competitive provisions in agreements, etc. In this case of Bancard, it was determined that the firm should cease discriminatory treatment regarding fees between clients receiving the same services. Also ceasing enforcing the exclusivity agreement discussing the case, and continue to provide services to the complaining bank until interoperability between processing companies is achieved. It was also stated that Bancard should refrain from the use of its platform as a condition for banks to offer discounts to payment cards users. Those remedies could be seen as an excess by some, but we believe that they are justified in the fact that Bancard is vertically integrated with some of the largest banks in Paraguay, them being the main shareholders of the company and also their main clients. So just cutting off the exclusivity agreement wouldn't be enough, since banks had no incentives to consider or to even consider other competitors. So it was needed to eliminate the it was needed to eliminate the preferential fees linked to exclusivity as well. Even with anti-competitive agreements, in our division, we had little experience with remedies. So we benefit from the experience from our colleagues from the mergers divisions, as they are trained to identify potential competition harm, and it's not atypical for them to design remedies regarding exclusivity clauses, which is partly the core of our case. So we record to their previous analysis, and they gave us the ground to understand the best way to achieve what we wanted.
Thank you. Catarina, I think the German experience is very much similar to the Brazilian experience, so what are the main advantages and drawbacks of choosing between commitment decisions and corrective measures imposed?
Thank you. Yeah, I have in recent years quite some experience with negotiating commitments. This is why I would like to say some words about that. Yeah, I mean the intention of this tool, the commitment decision, is to the early termination of a proceeding, and so that the competition authority does not have to go through the full investigation of the facts in a case, but only has to lay out the preliminary concerns, and then the company with market power offers, if it then offers commitments which dispel those concerns, and they are sufficient, we can declare those commitments as binding in a formal decision. However, I mean, it has been a very successful tool also in Germany. And several cases have been terminated by commitment decisions. It's already mentioned before, I think 4 in the past last 10 years, and there are still ongoing cases. I think you will terminate with commitment decisions. However, the process was actually in practice not as easy as it sounds maybe, or as I described it in the beginning, because in some of these cases the negotiations concerning the commitments took very long. And the problem is, I think, that other than in merger proceedings where you have a time limit for the negotiations and for the proceeding, there is no such time limit, at least in German abusive control proceedings. And this wise the affected company might not feel any time pressure really to speed up the negotiations and to offer commitments that we really can declare binding soon, because then they would have to terminate their abusive behavior immediately, and that is maybe not really in their interest. So in several cases, we had recently had the companies declared at a very early stage that they're really willingness to offer commitments, but the negotiations took very long, and the tactic was, for example, to prolongate proceedings by offering different commitments. Again and again, we had to go through market tests again and again, and they asked for more meetings to explain us why they changed the offers, and so on and so on. So at the end of the day, the sufficient commitments, in our view, were only offered after the Bundeskartellamt had actually gone through the full investigation of the case and drafted and sent a detailed statement of objection to the company to show that we really now would be willing to terminate the proceeding with a formal contestable decision if the commitment is not sufficient. So what I would like to say is that even negotiations concerning commitments can cost a lot of time and resources. However, I think still that it is there's great advantages because, first of all, you avoid court proceedings, which costs a lot of time and resources as well. And the remedies even sometimes might be more effective because you design them with the help of the dominant company, and maybe during the negotiation process you learn more about the pitfalls that might arise otherwise, and so that was really in some cases really of some help, I think, to make the remedies better. And also in commitment proceedings, the companies usually offer also or are willing, at least if we ask for it, to accept the monitoring trustee, which will be paid by the affected company. So this is of great assistance also to monitor the compliance with the remedies offered, and especially also if you need technical know-how to understand whether the remedy has been fulfilled really. So I think overall it's still a very good tool, but it has also some challenges. Thank you.
Thank you, Katarina. Now I want to give the opportunity to Mrs. Naoko to share with us some thoughts about what we raised here and make some remarks. Mrs. Naoko, the floor is yours.
Well, thank you for the opportunity. First, I think I would like to talk a little bit about the GFTC selection of procedures, in comparison between corrective measure and commitment, etc. And after that, I will introduce the GFTC's recent announcement for more effective commitment procedures. And at last, I will conclude with the expected role of the ICN on this matter. Let me first explain the GFTC's selection of procedures. The GFTC's basic policy with respect to unilateral conduct is to strictly enforce our competition law, namely by cease and desist orders, etc. And a cease and desist order has some advantages. First, the conditions under which a certain unilateral conduct becomes a violation of Anti-Monopoly Act would be clarified, since a violation is formally found by the agency. And if a lawsuit is filed after that, legal judgment will be made, and it may further clarify the criteria for determining illegality. And those will increase predictability regarding unilateral conduct laws. And also, as Anti-Monopoly Act prepares criminal penalties against non-compliance of cease and desist orders, the implementation of remedies is ensured by the criminal penalties. On the other hand, commitment procedures and closing of investigations with remedies have some advantages. In addition, and there is no necessity for elimination of violation requirement which exists with a cease and desist order. And furthermore, since investigation may be terminated earlier, maybe terminate earlier, and there will be no lawsuits after that, the FTC may save resources and use them to investigate new cases. And the number of unilateral conduct cases handled by the GFTC has increased in trend after we started using commitment procedures or closing of investigation with remedies. Although I don't think that is the only reason, but anyway, the number is increasing. And that shows that we could deal with competition programs in wider sections than before. And again, we have a basic policy of taking a strict measure, including a cease and desist order against unilateral conduct. And while if it is suitable in light of the circumstances and the characteristic of individual cases, we may use commitment procedures and closing of investigation with remedies, which have the advantage of correcting competition problems at an early stage. And procedure for each case is selected based on the characteristics of the case and the pros and cons of each procedures. Also, I want to introduce the GFTC's review on the operation of our commitment procedure. Our commitment procedure was introduced in our competition law in 2018, and the GFTC has continued to reflect for its effective operation based on our experience with commitment procedures. Based on the reflection, the GFTC made a public announcement last year that it will improve the operation of commitment procedures in 2 points. And the first, the GFTC has announced that the implementation period of commitment measure is expected to be at least 5 years in principle, in order to further ensure the recurrence of similar conduct. And before that, the implementation period in many commitment cases was basically 3 years. And various factors were taken into account in these considerations, such as the operation of commitment procedures by competition agencies in other jurisdictions, or the viewpoint of sufficient to recover the competition. And second, the GFTC has also announced that the GFTC will promote the use of monitoring by outside experts in the implementation of commitment measures. And before that, the company offering commitment measures itself reported its implementation after it implements measures. The idea is that the implementation would be more properly ensured with the objective monitoring of independent outside experts. But not just leaving to the use of trustees, the GFTC has also the FTC has also announced that when deemed particularly necessary in cases like ones which have a significant market impact or social impact, as the FTC itself will exercise its investigation power over relevant players, such as the trading partners or the competitors, as well as the company offering the commitment measures, to make sure the implementation. And at last, let me touch a bit about the role of the ICN on this topic. In unilateral conduct cases, remedies can take various forms, and there's no one-size-fits all remedy. Thus, agencies need to consider all the relevant characteristics or circumstances of the case in designing the remedy in order to sufficiently recover the competition. And I think in the area like this, it will be quite valuable for the agencies to hear and learn from experiences of other jurisdictions. And for example, I would be very much interested in knowing what specific aspects or characteristics of the case the agency paid attention to in designing a specific remedy, the effectiveness of the remedy, and so on. So those experiences of other agencies based on actual cases would provide a lot of insights which could be used in designing remedies in our investigations. So I think it's quite useful for the ICN to provide the opportunity to share experiences regarding remedies to keep us updated with new examples. So maybe that's all from me, and thank you.
Thank you, Mrs. Naoko. Let's move to the last part of this panel. We want to hear some closing remarks from our panelists. And I will start with Arturo. Arturo, please share with us your final thoughts.
This is ending, so I'm going to be a little bit candid about something. When we were discussing Not Gonna Come, what we wanted to share in this workshop, we were humbly aware that our banker case was a standout for us, but we doubted how engaging it would be for others. I know you probably seen dozens of cases like this in your jurisdictions, but we are really proud of this case because even though it wasn't well received by some powerful companies, and even though it was taken to court by the sanction firm in a minute, as it was expected, according to our monitoring, the decision helped to ensure the survival of some small competitors and has also led the dominant player to adjust some of its conducts and fight to maintain their position through improved services, which is beneficial for competition and our main goal. We are sure that remedies could really help us when it's needed to find the exact spot to fix the anti-competitive effects.
Thank you, Arturo. Catarina?
Thank you. I think since the more clear-cut cases in Germany are dealt with by civil courts, the unilateral conduct cases the Bundeskartellamt has to deal with or picks up usually are complex and all have their individual challenges. So from my experience, really remedies and orders have to be tailor-made. So I think it's really, I really have to say also too that it is very important, I think, such an exchange here in the ICN to have the opportunity to share our experiences and to help each other. And also, I mean, after this conference, as I said, all our cases are on our website. You can also pick up the phone and ask individually about individual cases. We also do that. Sometimes we just call other agencies and ask them about their experience in certain cases so that we can try to avoid mistakes that they think they made, so or learn from them what they think has worked really well. Yes, thank you very much.
Thank you, Catarina. And Mrs. Naoko, I would give you the opportunity to you to give us your final remarks, and I'm already thanking you because I know that's night in Japan right now, so thank you very much for the availability to be with us.
Thank you very much, from me, for this opportunity. And of course, I feel a little bit sleepy, but it's okay. And I also would like to thank other speakers for sharing their experiences, on this panel. And I learned a lot today. And for example, the idea of having a monitoring unit is quite interesting. And although I'm quite sad that I'm not able to participate in this workshop in person this time. I know that workshops like this are a great opportunity for us to be connected each other and contribute to building trust among agencies. So based on this experience, I look forward to working with you in future. And at last, I would like to extend special thanks to our wonderful moderator. Thank you very much.
Thank you very much. And last but not least, Sergio.
Thank you. Well, we have seen that unilateral practices and cases represent a big challenge for us because there are complicated cases, and designing the remedies could be one of the trickiest part of these big challenges. We have to be very careful when designing the remedies. We have to also monitor the remedies and check if the companies are fulfilling these remedies, and in case if don't, open sanction proceedings. We have all limited resources, so we have to prioritize our resources, and as Katrina has mentioned, just open cases, clear-cut cases when we have enough evidence to prove them and sanction them. And so we have to make the right choices. And to make these right choices, I think that events like this one is a very good opportunity to exchange practice, to learn from each other, and trying to work better in our job. So thank you for your attendance, and thank you, Ivo.
Thank you very much. We know that plenary sessions are more like setting up the scenario for the further discussions of the breakout sessions. So I hope this session was useful for you to go in these further discussions in the breakout sessions. And I would ask you, everyone, to join me in a big round of applause for our panelists. Thank you.
Thank you to all the speakers for their presentations. We invite everyone to enjoy the coffee break. Following the break, there will be 2 breakout sessions available for you to choose from. Data is a competitive parameters. Unilateral conducting data-driven markets in plenary room. The second one is standard and burden of proof in relation to exclusionary abuse in Jurunas 2 room. And after the breakout sessions, you are welcome to lunch in the hotel restaurant on the ground floor. And after lunch, we resume here at 1:30 for the afternoon plenary sessions in this room. And another thing is important, ladies and gentlemen, confirm your presence for the tour tomorrow with the 2 options, Christ, the Redeemer, or sugar loaf outside in the reception. Thank you. Enjoy your coffee break. Ladies and gentlemen, welcome back. I hope you all enjoy lunch and the breakout sessions. We now start the plenary session unilaterally conducted by public bodies and regulated markets. I have the pleasure of inviting to join the panel moderator Ms. Stephanie Guittard, Senior Officer at the Canadian Competition Bureau. Ms. Asanda Tunta, Investigator at the Competition Commission, South Africa. Ms. Asanda Tunta, Investigator at the Competition Commission, South Africa. Next one, Ms. Clara Kalanangwa, Investigator at the Zambia Competition and Consumer Protection Commission, will be with us remotely. Ms. Borja Martín, Chief Inspector at the Comisión Nacional de los Mercados y la Competencia, Spain. And Ms. Carolina Helena, Head of Unity at CADE, Brazil. Ms. Stephanie, as a wish. Thank you.
Okay, this works. Yes. Good afternoon, everyone. It's really an honor to be here today, and thank you so much to everyone at CADE. Oh, thank you for organizing this wonderful event and welcoming us here in beautiful Rio. We have a very interesting topic of discussion for you this afternoon, I find, that touches on a different set of challenges that I think many of us face in our work when it comes to conduct by public bodies and regulated industries. So today we've organized our discussion in three broad topics, starting with competition enforcement in regulated industries, which is where we'll spend most of our time. And then we'll take a closer look at conduct by statutory monopolies and close out this session with a discussion of the particular challenges that can arise when a previously controlled industry becomes liberalized. Given the broad nature of this topic and the specific challenges that are faced by agencies in regulated sectors, this session lends itself particularly well to case studies. So each of our speakers will be giving us a bit of a look at specific cases that illustrate their agency's experience with the topic. But before jumping in, let me introduce you to our speakers. So immediately to my right, we have Asanda Nunta, an analyst within the Market Conduct Division of the Competition Commission of South Africa. Asanda holds a master's degree in economics from the University of Western Cape and has over 6 years of experience in competition law and economics. She has investigated cases across a range of sectors, including energy, automotive, manufacturing, telecommunications, and digital platforms. To the far end of the stage, we have Borja Martín, a chief case handler in the Energy and Industry Unit of the Competition Directorate at the Spanish National Competition Authority. Prior to his work there, he worked in the public sector in Spain at the Ministry of Industry, Trade, and Tourism, where he focused on economic and budgetary management, as well as the preparation of public contracts. He also gained experience in the private sector as a design engineer in the automotive and aerospace industries in France. Borja holds a double engineering degree from Spain and France and is a member of the Corps of State Industrial Engineers. I believe you're also a teacher, right, of competition? Just a little bit, so very broad range of experience. And between the Asanda and Borja, we have Carolina Elena Fonts, who is head of antitrust analysis at the General Superintendent of CADE, where she has been working since 2009. Over her 16 years of experience in antitrust, she has contributed to cartel investigations, participated in the establishment of CADE's intelligence unit, and served for several years as head of a merger analysis unit. Currently, she leads the specialized unit for unilateral conduct investigations within CADE's General Superintendents, which was created in 2022 and has been under her leadership since its inception. Carolina also actively engages in ICN Unilateral Conduct Work Group and coordinates various projects and webinars addressing current global issues related to abusive dominance. And last but not least, joining us virtually, we have Clara Kalanangwa, a seasoned analyst specializing in mergers and monopolies at the Competition and Consumer Protection Commission in Zambia. She holds a bachelor's degree in economics with development studies from the University of Zambia. She has made significant contributions in the field of research, lending her expertise as a research assistant on various projects conducted by the Economics Department at the University of Zambia. So thank you to the four of you for joining us this afternoon and agreeing to take part in this discussion. And with the introductions done, let's get started with our first topic. So I think it's probably fair to say that many regulated sectors provide a fairly steady flow of work for antitrust agencies. I'm thinking of telecommunications, pharmaceuticals, energy sectors, and we'll see how things evolve over the next few years, but digital sectors may also be heading in that direction. Competition enforcement in regulated industries brings about unique challenges that can flow from the overlap between the activities of competition authorities and those of sector regulators. When activities overlap, there's a risk of inconsistent decisions or uncertainty for market participants. Cooperation between competition authorities and sector regulators can minimize those risks and help everyone achieve their objectives. During this first part of our panel, Carolina, Borja, and Sanda will share with us their competition authorities' experience with enforcement in regulated sectors and look at some of the more recent development in their jurisdiction. So I will turn it over first to Carolina to share Brazil's experience, in particular with investigations into regulated companies that attempt to exploit regulatory loopholes. The floor is yours.
Thank you very much, Stephanie. Good afternoon, everyone. First of all, I would like to express my great pleasure in participating in such an insightful event as this workshop. I hope the discussions are being as enriching for you as they are being for me. In this context, the subject of our plenary session is rightly relevant to the debate on how antitrust authorities should act when dealing with regulated markets and state-owned enterprises that engage in economic activities in competitive markets. I would like to share some insights on how antitrust enforcement in regulated markets works in the Brazilian experience. Brazilian competition law applies to both individuals or legal entities under public or private law, even if they engaged in business under a legal monopoly system in any market. So, CADE has the legal authority to investigate not only private companies, but also state-owned enterprises and any companies under the control of the federal government. Besides, CADE has a legal duty to investigate anti-competitive practice in any market, including regulated ones. So, CADE has the authority to investigate regulatory abuses, such as when a company uses procedures provided for in a regulation to hinder the entry of competitors into the market or exploit regulatory gaps to prevent a new entrant from gaining access, for example. CADE's case law is rich in examples of decisions affirming that the mere existence of regulatory authorization for a given practice does not grant immunity from competition law scrutiny. For example, a tax may be authorized by regulation, yet it still constitutes an antitrust violation if it's set at an exorbitant level with no other justification than to create obstacles to a competitor's access to an essential infrastructure. It's well established in CADE's jurisprudence that sectoral regulation and competition law enforcement are complementary rather than mutually exclusive. So, cooperation and close interaction between the antitrust authority and regulatory agents are very important to ensure that regulated companies do not engage in abuse of economic power and that regulations allows for the highest possible level of competition among service providers or in related markets that depend on them. And how does it work in the Brazilian experience? In practice, Brazil has 11 regulatory agencies, in addition to the Brazilian Data Protection Authority, ANPD, and the Central Bank of Brazil. CADE has signed technical cooperation agreements with 9 of these regulatory agencies to formalize technical and operational competition mechanisms, cooperation mechanisms. The idea is to encourage that exchange of information, data, reports, statistics, and the sharing of technical opinions and study results. On our side, these agreements aim to enhance CAD's capacity to detect and prevent anti-competitive practices, ensuring greater agility and effectiveness in investigative and enforcement actions. CAD has also a memorandum of understanding with the Central Bank of Brazil to strengthen cooperation between these public bodies, promote competition, and prevent abuse of dominant position in the national financial system. Naturally, this close relationship between regulatory agencies and the competition authority is essential for fostering more competitive markets. And it also aims to minimize conflicts over jurisdictions, although in practice, this is not always avoidable. Even with the existence of a cooperation instrument, conflicts may arise. The cooperation between CAD and regulatory agencies is not a new feature in the Brazilian legal system. It was already provided for in the previous competition law from 1994, but became even more pronounced with the enactment of the regulatory agencies law in 2019. This law reaffirms that CADE is responsible for enforcing competition law even in regulated markets. Regulatory agents should monitor market practice of regulated companies and notify CAD upon identifying potential violations of competition rules. Furthermore, CAD can request technical opinions from regulatory agents to support its investigations. In practice, this interaction is a routine part of our investigations in regulated markets. For example, when we receive a complaint about a possible unilateral conduct, anti-competitive practice in pharmaceutical sector, we can schedule meetings with the Brazilian Health Regulatory Agency, Anvisa, to understand the regulatory norms applicable to the sector, the background of the players involved, and to determine whether we are dealing with a private dispute or a competition-related issue. Another example is our cooperation with the Central Bank of Brazil, with which we hold regular meetings. This is a two-way street. We request their expertise to better understand the function of financial markets under investigation, while they report us certain practices, and we discuss together if each one should be a competition, a regulatory, or a private law concern. A particularly illustrative case of CAD's collaboration with regulatory agencies in investigation unilateral conduct is the Petro case. The relevant market involved was aviation fuel distribution, which is regulated by both the National Civil Aviation Agency, ANAC. ANAC is responsible for activities carried out inside airport areas, and the National Agency for Petroleum, Natural Gas, and Biofuels, ANP, which oversees the production, distribution, storage, and sale of fuels in Brazil. So, Petro is a small fuel distributor, filed a complaint with CAD against GRU Airport, the concessionary of Guarulhos International Airport here in São Paulo, as well as against the incumbent fuel distributors at that airport. Note that Guarulhos is Brazil's largest airport in terms of both passengers and cargo traffic. And the incumbents were BR Distributor, Raizen, and RBP Brazil, which together held 99% of the Brazilian aviation fuel market. Low competition in this sector has been cited as one of the factors causing aviation fuel in Brazil to be up to 40% more expensive than abroad, in addition to other factors such as taxation and Petrobras' dominance in fuel production and refining. Petrobras is a publicly traded company with both private and government ownership, in which the Brazilian federal government holds a controlling stake. Returning to the complaint, it alleged that the incumbent distributors of the airport, who controlled the shared infrastructure of the aircraft refueling park, were attempting to block Granpetro's entry into the aviation fuel distribution market at Guarulhos Airport. A key aspect of the case was that the airport concession contract signed between the federal government and the concessionary GRU Airports explicitly guaranteed free access for third parties who want to provide service for air transport. However, this contractual provision was being circumvented by another agreement, the lease contract for airport space signed between the incumbent distributors and the airport administrator, which stipulated that third-party use of underground fuel pipelines requires approval from the incumbent distributors. Surprisingly, these incumbents created all kinds of barriers to prevent Granpetro from using this essential infrastructure to provide services at Guarulhos. They alleged mostly safety concerns about the acceptance of Granpetro's. So, during the investigation, CADE engaged extensively with both the National Civil Aviation Agency and the National Agency for Petroleum, Natural Gas and Biofuels to verify the alleged safety issue and clearly define what was permissible under regulatory norms and what could be considered abuse of dominant position. Following a deep investigation, CADE's General Superintendent, that is the investigative body of CADE, concluded that the control over the underground fuel pipelines provided a competitive advantage to the incumbent distributors, who were artificially restricting access to prevent new entrants from using that essential infrastructure. Besides, the airport's concessionary actively contributed to this scenario by failing to curb the incumbents' abusive conduct. In fact, it had agreed with the contract containing the anti-competitive clause that allowed the distributors to function as a joint monopoly, blocking new competitors' access to the infrastructure. As a result, in 2020, CADE's General Superintendent recommended to CADE's Tribunal to the conviction of GRU Airports and the distributor RBP, BR, and Raizen. Additionally, in an advocacy effort, superintendents made recommendations for regulatory improvements to the agencies involved, as the need for greater clarity on the property rights of critical assets and the establishment of criteria and deadlines for the access of competition to aviation fuel distribution infrastructure in airports. 2 years later, CADE's Tribunal agreed with the recommendations of the superintendents and condemned the companies for violating competition law. This case is emblematic as it demonstrates that while sector regulation exists and works, regulatory gaps and failures can lead to disputes, encourage players to seek competition authority intervention. In our practice, we had observed that companies with market power in regulated sectors often exploit these regulatory gaps and failures to implement unilateral conduct with the aim of strengthening their dominance by preventing market entry or making it difficult for competitors to operate in this market. In conclusion, while I am proud to say that CAD is very efficient, with numerous examples of interventions in markets that were essential for competition, it's necessary to acknowledge that the antitrust authority has limited power, as it can only act in a specific case. Its rulings apply only to the companies investigated in each complaint or in ex officio investigations. So its decision investigations of unilateral conduct do not impact the market as a whole. This role falls to the regulatory agencies, as sectoral regulation has the ability to establish fair rules that must be observed by all companies operating in regulated markets. With clear rules and pro-competitive regulation, market failures are likely to be mitigated, and there will be increasingly less room for dominant players to implement anti-competitive practice. In this regard, it's important to highlight the role of the Secretariat for Economic Monitoring of the Ministry of Finance and CAD itself in advocacy efforts, ensuring that laws under discussion in the National Congress do not create artificial barriers to competition or market distortions, and that regulatory agencies' decisions take competition law aspects into account and assess potential competitive impacts of regulatory measures. So this is my contribution to the panel. Thank you very much for the opportunity.
Thank you, Carolina. This was a very interesting case. I do have a question for you. You mentioned at the outset that you have technical agreements with 9 of the 11 regulated authorities. Do you have more informal mechanisms for cooperation with the other 2?
Yes, in practice, we do cooperate. We just make a call and, oh, I investigate that market. Can you help us? And we just schedule a meeting. It's something very formal. We have these cooperation agreements, but the relationship between CAD and the agents, it can be informal, like a casual meeting. So let's have a meeting for you to explain more about that market for us, please. And it's a two-way street. They ask us, oh, I'm seeing that happening. Is this a competition issue or not, or just a private dispute?
Thank you. Turning to Asanda, I understand you'll be sharing the Competition Commission of South Africa's recent experience in using enforcement tools in the energy sector. And as you walk us through your experience, I would be curious to hear how much cooperation occurred between your agency and the regulator and the respondent during your investigation, and if that led to greater cooperation afterwards as well.
Thanks, Stephanie. Good afternoon, everyone. Thank you. First, I would like to send my appreciation to the ICN and CACHA for organizing this conference. So I think both Stephanie and Carolina alluded to this, that sector regulation and competition law are interconnected instruments, and the interaction of these instruments can vary across jurisdictions. And there are debates on whether these tools should be used as alternatives or as complementary tools. And those who argue against the joint application of competition law and industry regulation claim that competition offenses in regulated sectors may not have substantial liability or may lead to duplication of functions. And those who argue for joint application of competition law and industry regulation argue that competition is important in regulated industries, as you might have heard from Carolina, because it would address some of the regulatory errors that may occur, and it may also reinforce the promotion of competition in those markets. So we see these arguments play out in South Africa, where the Competition Authority has just recently applied enforcement tools in a regulated industry. In South Africa, the regulatory framework is that of separating the competition agency from sector regulators. In terms of South Africa, we view competition enforcement as complementary to sector regulators. As the regulators do have a role in promoting competition, but it's also complementary to the enforcement tools that competition agencies can also use. Some of the examples of industries or sectors that are regulated in South Africa include telecommunications, energy sector, the health sector, and the financial sector. As I've said, the competition agency in South Africa initiated investigative tools in the energy regulated sector. Just to give a background in terms of the regulatory framework in the pipe gas market, which is the case that I'll be talking about, there is a Gas Act that establishes the regulatory framework in this market. It describes the operation of transmission, storage, distribution, and gas trades on how to conduct these. And the South African authority established the energy regulator, which regulates this market. So the energy regulator conducts an assessment where it looks at the competition level or the concentration level in this market. And thereafter, it makes a determination on whether there is adequate competition in this market or not. After making that, it then determines a maximum price that could be charged for distributors, reticulators, and different classes of gas consumers. And it also issues these licenses to gas traders, and it also approves some of the players. So in 2022, between February and December, the competition agency in South Africa received complaints from gas traders and industrial gas users. They were complaining against a supplier, which is the respondent, alleging that the respondent is abusing its dominance by charging excessive pricing for pipe gas. So the Competition Commission of South Africa investigated these allegations, and as part of the investigation process, we do send out information requests to market participants and also including the respondent. But the competition agency in South Africa, we did not receive cooperation from the respondent. It did not respond to our information request. And the following step that we use in the Competition Commission in South Africa, we issue summons. But the respondent refused to comply with the summons as well, and it challenged the jurisdiction of the Competition Commission in South Africa, and it cited that the primary regulator is the energy regulator. Despite the lack of cooperation from the respondent, the Competition Commission proceeded with the investigation, and we relied on publicly available information and information from the market participants, which included the gas traders and the users. We received invoices from them, and we were able to conduct our assessment and to assess whether the respondent has charged consumers an excessive price. And the South African authority, we found that the respondent held a monopoly position for the supply of pipe gas, and the price that it was charging between the actual price it cost the incumbent and the price it was charging the consumers was high, and the difference was unreasonable. And we found that the respondent may have abused its dominant position by charging an excessive price to the detriment of customers and consumers. And the competition agency, we referred this complaint to the competition tribunal. It's important to note that the competition tribunal has not yet made a determination on this case. I think it's based on the challenges that we faced during the investigation, which I had initially alluded to, that the respondent did not respond to our information requests and also did not respond to our summons. Instead, it submitted an application to the competition tribunal I think let me just give a clarity in terms of, so the Competition Commission investigates, and then the Competition Tribunal in South Africa adjudicates, and we also have the Competition Appeal Court, which considers appeals or reviews some of the Competition Tribunal's decisions. So when the respondent refused to respond to our summons, it filed a review application to the Competition Tribunal, a two-part review application. In the first part, the respondent sought an interdict to stop the Competition Commission from investigating, alternatively to keep the execution of the summons. In Part B, the respondent sought an order declaring that the Competition Commission's decision to investigate and issue summons was invalid and unlawful. And this application was heard by the Competition Tribunal, and it was dismissed. So the Competition Tribunal held that the Competition Commission, once it receives a complaint, it has a statutory mandate to investigate. However, Part B of this application was referred to the Competition Appeal Court because in South Africa there was a court judgment that viewed that the Competition Tribunal does not have the jurisdiction to determine the jurisdiction of the Competition Commission. So the respondent appealed the Competition Tribunal's decision and filed a review application to the Competition Appeal Court. And the respondent argued that it cannot be subjected to two regulators, and that it was charging a maximum price that is not subject to the jurisdiction of the competition authorities, but it's within the jurisdiction of the energy regulator. However, the Competition Appeal Court dismissed that application and held that the Competition Commission of South Africa and the energy regulator enjoy concurrent jurisdiction. And the respondent tried to escalate the matter by appealing to the Constitutional Court, which is the highest court in South Africa, and the Constitutional Court declined the application, citing that there was lack of reasonable prospect for success. And in terms of, like I said, the regulatory framework in South Africa, we separate the competition authority from industry regulators, and it was clear from the court case that the energy regulator is responsible for regulating in the pipe gas industry, while the Competition Commission is responsible for regulating competition between firms in that market. And also in our Competition Act, Section 31A, it states that the Competition Commission enjoys concurrent jurisdiction with other sector regulators. And this also enables the Competition Commission, like Carolina mentioned, that we also are able to negotiate a memorandum of agreement with sector regulators. And before we had received the complaints in 2021, we had concluded a memorandum of agreement with the energy regulator to manage that concurrent jurisdiction. But based on the challenges that we had faced now with this case, both the authorities are looking at revising the memorandum of agreement. So key points from our case is that we view enforcement tools and industry regulation as complementary, same as Carolina has mentioned. And it was clarified that the energy regulator, it may seek to address market failures in the market, but the competition authority is responsible for regulating competition in that market. And that both the Competition Commission and the energy regulator enjoy concurrent jurisdiction. We view these competition law enforcement tools and industry regulation as complementary, and they reinforce each other, and they play a significant role in promoting competition in the market. Like in our case, the respondent tried to use the concurrent jurisdiction or having two regulators in the market to their own advantage by trying to leverage this jurisdiction and challenging the jurisdiction of South Africa and trying to delay our investigation. However, the judiciary in South Africa confirmed that the Competition Authority enjoys concurrent jurisdiction with sector regulators. This case contributes positively to the jurisprudence of concurrent jurisdiction of competition enforcement tools in regulated sectors in South Africa. And it's quite important, the discussions now with the energy regulator that we are having to manage the concurrent jurisdiction and to see where it's possible to share information, because some of these firms, when they submit information to the sector regulator, they claim confidentiality. Thanks.
Thank you, Asanda. This was a very eventful case. Do you have a sense of when the Competition Tribunal will issue its decision?
So we haven't even set for the court case. I think the respondent delayed even filing a response affidavit to the competition's decision to refer the case. We've just finalized filing our response affidavit now, so we will wait for the court case.
And they've now exhausted all of their potential.
Yes,
That's
yes.
good. Another quick question for you, and I may have missed this at the end, but when you mentioned that they refused to comply with the request for information and the summons, was there any information that the energy regulator had that they were in a position to share with you under the memorandum of understanding, or is that something that you're looking to introduce for the future?
So most of the information that we had required, the respondent does submit to the regulator because we needed their financial information to be able to do the price cost test. However, when they submitted that information to the sector regulator, they claimed confidentiality as it's a commercially sensitive information. So we were not able to use the memorandum of understanding or agreement to obtain that information. But what was useful for us in this case was that the respondent also is a public company that is listed in the Security Exchange, so we were able to obtain, use that financial information that is publicly available to be able to do our assessment. So we were not able to get the information directly from the sector regulator. Like Carolina said, we did have engagements with the sector regulator to sort of try to engage and understand how the market works. They also like initially when I said they do conduct an assessment to see whether there is inadequate competition in the market. So in their documentation, they do acknowledge that there is inadequate competition in the market. So thanks.
Thank you. Okay, so we've heard from two jurisdictions that have a competition authority that is apart from the regulators, but now we're turning to Borja, who's going to tell us about Spain's experience, where the competition authority is a multifunction body that combines competition and regulatory authorities. So I will turn it to you to tell us about your experience, but I believe you have a PowerPoint, and
Yes,
I'm going to give this.
Okay, so in the meantime, I would like to thank to the CADE for the organization of the event. It's a great pleasure to be here in this panel. So, as Stephanie said, I will present first my presentation in two blocks. It's interesting to have a different vision of the CNMC, which have integrated the sectoral regulatory institutions and so also the competition authority. So I will also bring some examples about the evolution of the policy for competition and regulatory that brings to us to have this configuration to this day. And after that, I will share some cases that we have detected and it was sanctioned through competition thanks to the collaboration with the sectoral law. So here I will bring you some historic milestones because it's important to know from where we coming. So as you know, we need to separate here in two levels, the European Union evolution and also the Spanish evolution. On one hand, we have a competition policy development in the European Union. It has always been a really basic pillar for the for the community to have a free trade, free movement of services and goods, and to have a better price, better quality, and so on with competition. But as you know, in 1980s, there were a liberalization process with this really heavy and sectoral sectors such as energy, telecom, transport, that lead us to implement new private actors and new competition in this process. So on the other hand, we have the Spanish evolution that you know that we passed from a dictatorship regime from a democracy in really short period of time, and we need to adapt the institutional law to be able to integrate it in the European Union. So this is also a remark that I would like to do, that is in a really fast track record we have bring institutions to tackle problems with regulatory and competition. So I want to deep in this evolution of the institution. So on one hand, from the 90s, when the liberalization process, the liberalization package that came from the European Union, when translated into the national rule of law, we created a cumulative and really high number of regulators dedicated only for each particular sector. We have the National Commission of Energy, Telecom, Railway, Airports. So this was each one was making their own decisions, and they were focusing on the development of these new liberalized markets. And that is why maybe the decisions that they take, they were not followed, they not run in parallel with the competition authority. There were misunderstandings, so there were sanctions that were maybe contradictory. On the other hand, we have the National Competition Commission that were, we will say, changed in 2007 with the new Spanish competition law. That they created an independent and separate institution with a council and the instruction department together to tackle this part of competition. And finally, in 2013, you know that we had an economic and financial crisis, and the government decided to join all the national regulatory authorities and the National Competition Authority in what we know today, the National Commission on Market and Competition. It was not an evolution of the proper institution, it was just a political decision. It is true that there is a lack of experience at the global level for this kind of configuration, but I think in Netherlands we have some example, and also maybe I read that in Mexico, New Zealand, we have this kind of distribution, but for us it was a little bit criticized because this was something new. And now I put here 2025 because the government is also trying to separate the National Commission of Energy from the multisectoral CNMC. So we will see what we will get in the next year. So here I have the organizational chart for the CNMC. You see all below the instruction department. You see that it's integrated the competition directorate with the energy, telecom, and postal and audiovisual services. So thanks to having the same boss, we will cooperate and be coordinated in a better way than if we maybe sign some assignments with the other entities. So I think this is a goal for the cooperation and coordination. And here it is also true that we merge all the council from the different sectoral authorities and the competition authorities in one. It is true that we have two boards, one from regulatory, another for competition. And this is also helpful that in the law it is written that a competition board could know about the subjects that are treated in the regulatory board. So this is a good exchange of information from what is happening on the other side. As you know, we focus into the historic milestone. You know perfectly that competition law and regulatory has different triggers. They have different forms to tackle the problems. One is focused on the market regulation to avoid the market failures and so on, and the competition wants to have effective competition implemented. They have different process from sanctioning. One is it must be typified in the law. The other one you can tackle through collusion, abuses of dominant position, and so on. And as I explained before, the evolution make that regulation and competition in the 1980s, it was a little bit separate. They took different decisions. There was this kind of dysfunctionment. But now we have a really good interaction between these two sectors, competition and regulation, and it is a lot of synergies that have been raised up due to this structure of the CNMC. We have examples of we can now make better regulation thanks to competition sanctions. We can make decisions between how to tackle a case. It's better to do it by regulation. It's better to do it by competition. And this kind of interaction, I think, is also relevant to take into account with this configuration. To sum up this first block, I will talk about the different approach or enforcement that NRAs, which are the sectoral regulatory entities, and the NCA, which is the competition, accounting, functional and legal separation. So now the regulator need to see if this is okay, or you need to sanction to be able to do it really. So they also perform consumer protection activities. They have the switching office when you change from energy from one retailer to another one. The CNMC is also observing if this is done okay. They also make market surveillance through REMIT, which is a new rule that comes from Europe, and it's all seeking to have a control from the wholesale market of electricity. And then you have, as I said, the sanctions proceeding through the Regulatory Act. And on the other hand, NCA enforcement, you know really well, we make downgrades, we make merger control, sanctions through abuse of dominant position, collusion. But what is important here that I will talk about after is the cross-report analysis. As I said, both boards of the national CNMC, they are joint and they can know the topics that are discussed in the other one or another board. So, for example, if they detect a problem on sectoral regulation, they can raise to competition, and competition maybe can examine that and then perform a proceeding and a sanction. So this is interesting. So now to jump to the second block. Now I will express some enforcement in this regulated market in the energy sector, because I'm working in the energy industry and industry subdirectorate, so I will focus in this regulated sector. And before tackling some examples, I would like to make or give you some notions to understand what is coming after. So as you know, we have a value chain here in the electrical sector and gas sector that are performed like generation storage, which are in green. I put the liberalized activities, in red are the regulated activities. On the liberalized activities, we have generation and the retail, which are performed in free markets. We have a wholesale market and the retail market. And on the other hand, we have the regulated activities. The income of these activities comes from the state. They have the transmission, distribution, and the regulated market of the retail. Transmission and distribution are natural legal monopolies, and the retail part that are regulated is due to protection for the vulnerable families. And I put also the GTS here in the left, because it is also interesting to have a technical manager that is able to protect all the infrastructure and assure that all the energy through electricity or gas can arrive into our homes. And it is also responsible, this GTS, about the planification of the grid. So here I will jump to the first case on the gas infrastructure market. Here we present an abuse of dominant position of a company that is called Enagas, which is the technical manager of the gas grid. And here, what we want to show is that there were an exclusion of a third competitor that were operating in the infrastructure market. This competitor had a regasification plant, you know, to put liquid to gas. It can change from liquid to gas, the natural gas. And this company made a complaint through the CNMC and claimed that this Enagas company was trying to exclude it from the market. And as you know, we have a vertically integrated Enagas company which performs the technical manager and the TSO, because Enagas is also responsible for maintaining the transportation infrastructure. So here, as the rule of law says, they need to be accounting, legal, and functional separated. So in that case, it was the GTS, the technical manager, who tried to exclude Reganosa, who was the competitor from the regasification market. And how do we presume that he did it? It was like through a structural limitation and operational limitation. The structural ones are based in physical limitation. For example, the technical manager could tell you, now we need gas in the south of Spain, you need to put gas through Reganosa or in a gas regasification plant. So these switchings can give some exclusions of the Reganosa plant. Another one, it was the operational limitations that through contractual limitations, the technical manager can also exclude or preference another regasification plants rather than the Reganosa one. So this was a discriminatory strategy that was performed from the GTS, Enagas. The competition authority made some down rates and several requests for information, but in that case, we didn't found that this regulated company performed a strategy like it was said in the complaint, because even if he has the power to decide, okay, we will amplify the pipeline to put more gas because there is maybe congestions, and this plan is getting, also this regasification plan is getting out of the market. The Spanish government is the final person institution who takes the decision to amplify or reduce or change the gas infrastructure. So here there is no dominant position from Enagas. He cannot perform this kind of practices. And also in the process operation, as you know, in Spain we have a gas system configuration that is oversized. So we cannot affirm that there is an exclusion of Reganosa, this competitor, because the process were well applied and they respond to this oversized gas system configuration. It does not respond to an exclusion. So this is why this case was finally closed. So I changed to the electrical sector. In this case, we perform a sanction through the competition department. And here we have an abuse of dominant position in the third access parties to the Spanish electricity transmission network that also, as I will explain, they will have an effect on the related electricity generation market. Here we have, as I said, the technical manager is responsible to give access to the grid, to the electricity grid. So any obstruction of this process could be managed as an exclusion. Here it is true that Red Eléctrica is the company I have put here in the right, is the responsible of the transmission grid. It was by law. There were a function that was externalized through a third private company. So he has a special privilege administrative privilege to engage all the requests from the promoters that wanted to access to the grids. As you know, in Spain we have nodes, which are the plugs where you can connect your renewable installations, and these promoters are competing for having enough capacity to develop their own infrastructure. So, you know, the capacity is limited. So now there is someone, which is Red Eléctrica, that need to decide which company will get the capacity to build the infrastructure. So here, as I said, this is the normal process, but the law gives us a third company that can externalize this kind of activities. Not to decide who is going to have the capacity, but to facilitate, to make the life easier for the technical manager. So here I put it on the right an explanation of what I'm talking, because I know it's not easy. So there are here several promoters that they want to build, I don't know, aeolic, photovoltaic infrastructure, and they need to request to the technical manager, Red Eléctrica, that they wanted to pursue this development. So they need to fulfill some economical and financial warranties, technical management also they need to perform that, and after an evaluation, this capacity will be finally assigned or not. It is true that the CNMC has a protocol that if someone is not, does not agree with the final decision of this third company has taken to share all the capacity, you can bring an access dispute to the CNMC, and the CNMC will study the case, and we will have an administrative resolution, and that will say you are the right one or you are not the right one. So this is a process that there is no sanction here in this process. It is just an administrative procedure. But thanks to that and what we said before, that one board from the CNMC can know what the other board is making, we can tackle this through competition. In that case, for example, the regulatory framework didn't have a typo of sanction from this kind of cases, because it is true that this new figure, it was not really well developed. So in that case, we decided to tackle through competition, that it was an exclusionary abuse. So here I resume what I say, the facts. This is really, really important, because we didn't need to make down rates and anything, because the record that the Energy Department made to us, it was enough to make this sanction. After that, we tried to identify the market, the access to the third party to the transmission grid. They were in a dominant position of this company, because he has special administrative rights. Even if it's private, he has a special administrative rights. He was in charge of taking all the coordinated submission and request and to pass it to the technical manager. So in that case, he preferences their own infrastructure, exclude the infrastructure from third parties, and also he obstruct the action of the technical manager. So here we perform discriminatory abuse with effects, with exclusionary effect. We perform the test that they fulfill the three requirements from the discriminatory abuse. The request from both competitors were equivalent. There were unequal conditions, because even the competitor requested first the capacity, this special company decided that this was not the case. He was self-preferencing their own facilities, and there were also a competitive disadvantages, because without the access dispute and the report from the Energy Directory, this company wouldn't have get any capacity. And the exclusionary effect is clear that this company gets out of the market. He cannot connect to the grid. He cannot perform some generations. And finally, I will just sum up 3 cases that are ongoing from also the energy sectors in the CNMC. We have problems, or we have an possible abuse of dominant position in the meter installation from the electrical sector. We have one DSO or distributor that is preferencing their own meters and is restricting another markets related to the data and so on, but I cannot say anymore. The other 2 are also related to the electrical sectors, and we have unfair practices in the second one from another DSO distributor that is maybe preferencing their own vertical retail company against third parties. And finally, we have another case in the distribution market from electricity that is more related to self-consume, and some prioritizations that is the same. It's prioritizing their own vertical retailers against third parties. So this is what I wanted to say here in the first slot.
Thank you, Borja. The second case you talked about, you mentioned that was an internal decision that was made to address it from the competition side. Is it the case for all of the cases that you're pointing us to right now, where it's an internal decision that is made, the information comes from the regulatory side?
From this case, in the electrical sector, it is true that it was this exchange of information, the report we can use to tackle it through competition. But on the gas sector, this was coming from a claim from a third competitor. So this is not the same approach. Okay. One came from a claim from a third competitor, and here we use this record, from the Energy Directory to tackle this problem.
Would you say there's generally a strong competition culture on the regulatory side to make sure that that exchange of information happens seamlessly?
Can you repeat, please?
If there's a strong competition culture on the regulatory side that makes sure that the information gets transferred very easily.
Now, I think with the configuration of the CNMC, yes. But as I said, in the past, there were communication, but the coordination was not set at the same approach. We'll say that with this new configuration, we have a better coordination and better communication between the...
Thank you. So this concludes our section on enforcement in regulated industries, and we're going to turn now to the second topic, which focuses more on conduct by public bodies. So with this, we'll turn it over to Clara, who's online with us, to tell us a little bit about Zambia's experience in that area. We can't hear you, Clara. Clara, can you hear us?
Hello?
We can hear you now.
Okay. Thank you so much for the opportunity to speak and to interact with competition experts. I wish I could have been there physically, but either way, it's nice to sit in and listen to the various perspectives on the one common thing, which is competition regulation. So I'm going to bring it down to Zambia and just speak a little bit about our experience in dealing with public bodies, especially when the public body is the offender. I'm going to talk about the competition, the Zambian Competition Tribunal ruling on a case involving our national airports, which is the Zambia airports, and how such a ruling can impact the effectiveness of competition enforcement. So this is a case between the Zambia Airports Limited and the Competition and Consumer Protection Commission here in Zambia, as well as the Export Growers Association, who in this case was the complainant. So the complainant had alleged that Zambia Airports was denying it access to the common use terminal equipment system, which is a critical system for aircraft load control and balancing. So what was happening was that the complainant had been accessing this system initially, but then Zambia Airports put up certain conditions and conducts, which made it harder for the complainant to access these systems. So the restrictions are also related to imposing certain fees that the complainant deemed to be unfair. So there was also a complaint relating to discrimination in the charges. Zambia Airports had imposed a charge on the complainant for use of certain features such as check-in counters, which increased the cost, the operational cost of the complainant, whilst at the same time putting Zambia Airports at an added advantage, as it was able to undercharge its services. So there were charges that were imposed by Zambia Airports on the complainant relating to water and toilet dumping facilities, which were disproportionately high compared to their service charges. There was also an alleged abuse of market power. Zega, the complainant, claimed that Zambia Airports attempted to limit its ability to compete by discouraging airlines from engaging with the complainant directly for services such as ground handling services. Zambia Airports allegedly provided preferential treatment to other players, whilst disadvantaging the complainant. So this alleged conduct was investigated by the Commission under the provisions of our Act, and specifically we focused on denying access to essential facilities, unfair restriction and predatory pricing, as well as price discrimination. The Commission in its findings found that Zambia Airports had abused its dominant position and was in violation of the Act. However, this case was appealed, and here are the tribunal findings. So the tribunal ruled that in Zambia, Zambia Airports is classified as a government monopoly. And this is because it is 100% government owned and operates under the laws of the Republic of Zambia. A statutory monopoly is a commercial entity whose activities are legally protected from statutory obligations. So governments create statutory monopolies to control essential services such as telecoms, electricity, water provisions, etc. Zambia Airports had exclusive rights to operate Zambia's 4 international airports. And in this case, there was no legal provisions that existed to allow competition in airport operations or ground handling at the time of the complaint. The tribunal also referred to the Act, the Competition Act, which states that the Act will only apply if the market is open to competition. And since Zambia Airports was deemed a statutory monopoly. It operated in a closed market with no competition. So the tribunal ruled that the act did not apply. The tribunal ruled in favor of the appellant, Zambia Airports, and stated that the case was thrown out because competition does not apply to statutory monopolies. So from this case, what does this imply and what does it show for competition law and the enforcement of it there? This ruling confirms that competition law does not apply to statutory monopolies operating in legally closed markets. This creates a regulatory gap, as traditional competition law tools such as abuse of dominance cannot be used to address inefficiencies or unfair practices within these markets. Without competition or strict oversight, statutory monopolies may become inefficient, leading to risks of inefficiencies, higher prices, poor service deliveries, without the enforcement of competition to remedy such behavior. Regulation of monopoly pricing and contracting practices. So the ruling found that there was an element of discriminatory pricing which existed, but this was thrown out because it was regarded that it did not amount to an abuse of dominance due to the lack of competition in the market. This highlights the need for certain regulations to oversee fairness in markets that are deemed to be monopolized by statute. As competition law cannot be used to challenge potentially exploitative pricing in legally protected monopolies. So this also enhances barriers to market entry in that if monopolies remain legally protected, new entrants are not able to enter such markets, even if we consider deregulation at a later stage. This ruling reinforces the need for clear transitional plans if a market is to be opened to competition in the future. Other regulatory reforms. This ruling also signals that competition authorities may not be able to regulate statutory monopolies effectively unless certain laws are amended. Policymakers may need to consider deregulation, perhaps even in extreme cases, price oversight or alternative market structures to balance the benefits of legal monopolies with economic efficiencies. And in conclusion, a review of sectoral regulations may be necessary to ensure that public monopolies operate in a way that serves consumers and national interests. Thank you very much.
Thank you, Clara. I think this is a very interesting case from the Canadian perspective, at the very least. It's very similar to a case that we had involving also an airport authority. There are obviously some significant nuances, but we reached a slightly different conclusion where our public bodies, where they are engaging in economic activities, we have a fairly recent ruling that determines that they are subject to competition laws and they cannot avail themselves of a defense that says that because they act under a statutory mandate or a legislation that they are therefore shielded from competition. So we have reached slightly different conclusions in that area. I'm looking at the time. We still
okay,
have... Go ahead, sorry.
I just quickly wanted to react to that and say that this ruling also has been appealed and is currently at the High Court. So we're hoping for a different direction, hopefully in future. Thank you. Thank you so much.
Thank you. We have a little bit of time left, and we had one more topic that we were hoping to be able to touch on, and that's the case where a previously state-controlled industry becomes liberalized. And I will turn it over to Borja again to tell us a little bit about Spain's experience.
So thank you. I will also need the slide. Thank you. So here in this second slot, I will talk about how these old state monopolies, even if they have been liberalized, privatized, and they are also suffer the deregulation process, so that means that the presence of the state has been reduced. There are still huge dominant positions in these regulated markets. Regulated markets, as I said before, like air transport, telecom, and energy. So I put here a table that make a summary of what I told you before, that in the 80s we got a liberalization process, a regulation process to put the rules of these new markets that then they needed to be separated from monopolized, legal monopolized activities from liberalized activities. And also it's interesting to know that in that case in Spain, we took the decision to privatize, to pass it through public entities through privatization, even if they are performing regulatory actions. So here, I come back to the energy sectors. Here we have some slides to show you that there is still dominant positions from these companies that are vertically integrated and have the distributor in the configuration of the company. Here in the electric sector, on the left side, we have three main companies, like they are called Iberdrola, Endesa, and Naturgy. They have all of them are distributor integrated, vertically integrated in the company, so they perform in the generation market, distribution, and also in the retail. So as I said before, in the cases, if there is this kind of economic interest, there will be always a preference to take better their own retail from the integrated company rather than third competitors. So this is why we have this kind of market shares in the retail sector. There is still this problem. And this market share will be, you see here that it's only 33, but if you take the area where the distributor is performing its activity, you will see market shares around 80%. So all the connected points in the retail market that are in the distributor area, they are take part from this vertically integrated company. So this market share, they are not really 33% because this is managed as a national level, but as I said, if you look at a distribution level, the area where the distributor is performing its activity, this market shares will be higher. And also, as I said, the CNMC performed the switching office. That means one client decide to change from one retail company to another one, the CNMC trace this change. And here we have also interesting percentage that show us that, for example, here in the middle we have the regulated market, and on the left side and right side we have the liberalized market. We see that there is still electrical companies that try to perform activities to pass clients from the regulated sector to the liberalized sector. In the liberalized sector, they win more money because in the regulated sector, you pay from the price from the wholesale market of the electricity. So what they still are doing is try to change this kind of clients from the regulated sector to the liberalized sector. So there are still some percentages that are interesting to know. No? And this is only evidence, but maybe if you perform some studies or you make down rates or something like that, you can detect maybe that there is something behind or not. So this is what I wanted to share you here in this blog.
I'm curious to know if in that process you've received more complaints from the sector about potential problems stemming from this.
Yes, so we will receive many complaints. As you can see in the previous proceedings, we are performing investigations on that, and we are studying it. But it's an evidence that.
Yeah. I think over the last few years in Canada, and I can't really get into the specifics of those, but we've seen a few sectors that have wanted to move from a public-controlled environment to a privatized one, and it has generated tons of complaint and taken a lot of work to try to figure out what's going on, and because the entity that was initially controlling the sector is allowed to participate in this newly created competitive market, and they start with an advantage and a fairly large market position. So it's just been interesting to see that evolution and trying to determine, are we really facing issues with abuse of dominance with an incumbent that's starting off with an advantaged position, or do we just need to give the market some time to settle a little bit before we're able to really do a full assessment? And I'm just wondering if that's been a little bit your experience as well.
Yes, as you can see here, for me it's clear, but we need to have the clues, the evidence to prove that, and it's a little bit difficult to have that.
Okay, we have maybe time for a few questions from the floor, if there are any. Otherwise, we give everyone 5 minutes back.
Is it working? Yes. Hello, thank you for a very interesting panel. I have a question that I have a question that is more for Borja. I would like to understand from the Spanish framework, how is the relationship of coordination in the context of the DMA? And also, yeah, I know that's already quite complex, but also I know that Spain is the first country that introduced an agency for artificial intelligence that will coordinate, supposedly, with other agencies in the government. And perhaps this can also involve competition issues. So I wonder if there's any discussions or formal coordination mechanisms that are being envisaged to coordinate with that agency as well. Yeah.
So I think I'm working in the energy department, so it will be a little bit difficult to answer to that, but I think this DMA has been approved, and the CNMC need to take a new structure to integrate this kind of new instruction department for the DMA. But honestly, I don't have the information for these new coordination processes that will be applied. Sorry.
Okay. So with that, I'm going to thank you all for an interesting discussion and for your participation. And I will... oh, there's another question. I missed a question. Andrew, I'm so sorry.
Thank you very much, Juan Stephanie, for facilitating an excellent panel, and to the exceptional panelists for your presentations. One question that I have, which applies to certain of the panelist members, is that it appears as if there are multiple memorandums of understanding and other agreements that you have with various sectoral regulators. And as you pointed out, our colleague from South Africa, in certain circumstances, there have been issues with the communication of commercially sensitive information in the possession of that sectoral regulator. So within your respective jurisdictions, how have you been able to circumvent, we'll call it those issues to gather commercially sensitive informations, and within those agreements themselves, are there any specific provisions that may permit you to communicate commercially sensitive information to and from those regulators?
I can start, Karen. Thank you, Andrew, for your question. I think that's part of the reason why the Competition Commission of South Africa and the energy regulator in South Africa are going back to the drawing board. Because I think with this case, we realized the restriction of the commercially sensitive information and how it would have assisted the Commission maybe with the turnaround of the case. And yeah, I think we are having those discussions, but we can also not contravene by the sector regulator cannot contravene the confidentiality of the players, because they still need to annually submit that information. So if they now share it with the competition authority without their approval, it may impact that relationship and that cooperation as well. So I think it's just going back as a drawing board, and I think I'd also like to hear from Karina in terms of how you guys are going about navigating that. Thanks.
Okay, in Brazil, I think we don't have a lot of problems with that, because with our memorandum of understandings and the agreements, we can share this kind of information in the majority of the cases. I can't think now about a specific case that it's not possible. But usually we can share this kind of information once we are in the same side, in the side of the government. So yes, in a lot of, and of course we keep the confidentiality of the informations. Only CAD has access, or only the regulatory agents has access. But we used to share this kind of informations.
From our side, we are integrated in the same structure, so internally we can share the information, but if this information has been requested as confidential outside, we made the same treatment, but internally we can share more information. We can use confidential reports that has been done through the energy direction. We can use it, and then we can treat it, and we respect the confidentiality in that case.
I think we have different agreements with different regulatory agencies, right? So when it comes to telecommunications, there are certain rules there, and with other agencies, there isn't that possibility to share information. So it really depends on what agreement we have in place, or what regulatory framework is in place. So it's not a one-size-fits-all for us. And with that, it's the coffee break. Thank you again.
Thanks to the speaker for their presentation. We invite everyone for a coffee break, and after the coffee break, we resume here at the 3:15 p.m. for the second plenary unilateral conduct and price-related practice. Resale price, maintenance, RPN, presale rule, or reason analysis. And the important thing, ladies and gentlemen, don't forget to confirm your presence for the tour tomorrow. Okay, is we have Christ the Redeemer or Sugarloaf outside in the reception. Please, thank you. Nossa, quase não sai. Mr. Luke Asher, Principal Investigator at the New Zealand Commerce Commission. Dr. Yolanda Martinez. Dr. Yolanda Martinez, AG, of the Comisión Nacional de los Mercados y la Competencia en Spain, and Ms. Sharon Clancy, Executive Director, Competition Enforcement and Advocacy at the Australia Competition and Consumer Commission. Please, Ms. Mandel, the word is yours. Thank you. Antes de começar. O moço bateu, mas... Aqui. Então deixa. Ladies and gentlemen, I have the pleasure of inviting to join the panel Unilateral Conducting Price-Related Practice, Resale Price Maintenance, RPM, per-sale Rule of Reason Analysis. Please, moderator Ms. Barbara Rosenberg, NGA from Brazil. Mr. Luke Asher, Principal Investigator at the New Zealand Commerce Commission. Dr. Yolanda Martinez, NGA of the Comisión Nacional de los Mercados y la Competencia, Spain. And Ms. Sharon Clancy, the Executive Director, Competition, Enforcement and Advocacy at the Australia Competition and Consumer Commission. Ms. Barbara Hazubishi, the word is yours, please.
Hello. Well, thank you very much. Good afternoon to everyone. I'm truly honored to be here today moderating this panel on our project. And in that sense, we had already the chance to interact a little bit. And before, in any case, we dive into the topic, I'd like to take the advantage to thank very much for the opportunity. And it's an honor indeed to be moderating this panel. And I thank Kaji for this opportunity. And also thank the organizers for curating such an interesting and thorough event. Thanks, Alessandra, for organizing and putting this together. And thanks to Kaji officials and all the ICN group. We do have here a very exceptional group of speakers. I have right on my hand side Sharon Clancy, who is an executive director in the ACCC Competition Division, where she leads the advocacy team for about almost 30 years at this point, which is very impressive, and it's possible to know the deep knowledge that Sharon would bring to our panels. She has worked at the ACCC on enforcement, executive mergers, exemptions, and international areas. We also have here Luke Archer on my left-hand side, who is a principal investigator at the competition investigations at the New Zealand Commerce Commission. I won't say the name in your language, but maybe. He leads the team of investigation responsible for anti-competitive conduct investigations, including RPM. He previously practiced on major firms in Wellington and Melbourne. He has an LLM from the University of Toronto and an LLB from Victoria University in Wellington. And then the other NGA here with me in the panel, Yolanda Martinez Mata. who is a partner in competition law and European Union at Marimon Abogados in Barcelona. She has a PhD from the University of Barcelona and a thesis on abuse of dominance, and she is a lecturer in the European Union law, competition law in the University of Barcelona. So clearly people with substantial background and information to share. Unfortunately, Ms. Mapato Homokopa from the South African Authority couldn't make it to the trip. She apologized, but we'll bring a little bit of what we discussed in relation to South Africa. And indeed, just now getting then to the topic, when we look into that, we see that in a large number of countries, we see what we could call like a per se approach or a non-effect assessment in terms of RPM, such as South Africa, Japan, South Korea, Australia, New Zealand, and Europe. And we are going to talk, again, when I talk about Europe, we know that we do not really use the concept of per se, but we are talking about conduct by the object, and we are going to be dealing on that deeper. And on the other hand, you have countries like the US that had a federal regulation that actually a federal decision on the alleging case since when the case has been treated under the rule of reason. In Canada, as far as we've studied, we also have a rule of reason approach. We know we have Canadians here on the audience, and feel free to jump in and collaborate on that. And in Brazil, we also have what would be a rule of reason approach. And in fact, even though we do have those categorizations, it's not that there are many things that goes around what that really means in terms of assessing effects, trying to find justifications, and understand to which extent this is a conduct that might have pro-competitive or anti-competitive effects, how they can foster or not inter-brand competition, and a number of points that will be dealing. So we thought about dividing this in 4 different parts. We're going to talk a little bit about RPM as a vertical restraint, assessing the potential of the anti-competitive effects and inter-brand competition and so. And then we're going to spend some time really looking into what it means to treat it as a per se or a under the rule of reason approach. And then we're going to talk a little bit about the e-commerce and all the digital challenges that comes along with the practice. And lastly, some of the challenges that the enforcers are facing in relation to that. So maybe just to put the ball rolling, I'll turn to Yolanda, and I'll take, Yolanda, from something you made even a good question, I would say, when we were in one of the prep sessions, saying that from an European perspective, it sounded interesting to hear that there would be a panel on RPM in a unilateral conduct conference. So maybe just to understand and to frame the situation, I'll ask you to comment on that, and if you want to bring also some general views of how this is treated in Europe and in Spain, please.
Okay. Well, thanks everyone for inviting, for organizing this event here, and thanks Barbara for organizing this panel. Let's address first the elephant in the room. As Barbara said, one of the first questions we addressed during the preparation sessions was, why are we talking about RPM in a unilateral conduct workshop? It is true that some of dominant situation, and let's, of course, not the collusion effect, which by definition needs 2 firms to collude, but let's think of the reduction of intra-brand competition, which is normally associated to RPM, which is the evident effect. Of course, the reduction of intra-brand competition will be much more harmful to the market, to competition dynamics, in a situation where inter-brand competition is not fierce, and in particular when there is dominance. So yes, we can find there a first relationship. Another anti-competitive effect related to RPM is normally the capacity to foreclose new entrants. At least the guidelines of the European Commission, in our case, specifically state that possible anti-competitive effect. And I fail to see how one could foreclose competitors via RPM if it were not dominant. So unless you're dominant through RPM, it's difficult that you can convince your distributors to only buy your product because they have enough margin and therefore not devote investment efforts or other promotion efforts to make your potential competitor, the so-called new entrant, not to enter the market. So this capacity to foreclose the market probably is much better understood in a case of dominant position. And then from another perspective, which I also considered when we were preparing the panel, I guess, and let me be provocative here as an NGA, I guess there's a certain bias from enforcers sometimes when you deal with RPM, because normally it's the supplier who is fined for an RPM practice, whereas it's supposed to be a 101, so an agreement, a bilateral conduct, which by definition needs two parties, and therefore it would seem logical that the two parties involved in the agreement are fined. Whereas you would find in many jurisdictions, and I'm not saying it's not for good reasons, of course we may understand that it's the supplier who is imposing the RPM, but yes, there's this certain tendency in some RPM cases to understand that it's the supplier only who is imposing the RPM on distributors. So just that to set the scene and try to find some logical connection with the unilateral conduct and why to discuss RPM in a unilateral conduct workshop. And about the approach in Europe, you want me to address that now? Yes? Okay, so as I said, we have Article 101 of the treaty. We have, well, this general provision in general forbids agreements between undertakings that may, by object or by effect, affect competition in the market in very broad terms. And this finds concretion in the case of vertical agreements in a block exemption regulation on vertical agreements, which says that fixing prices or determining minimum prices in a distribution relationship is forbidden, and it's a hardcore restriction. Whereas maximum or recommended prices are in principle valid unless they amount to an indirect means to fix prices or to set minimum prices. With this general provision, we have also guidelines explaining how to apply these provisions, these articles, which were amended recently in 2022. And I guess there you will find the generally accepted anti-competitive effects and maybe pro-competitive effects also of RPM. And they state, a certain status where at least the consideration of pro-competitive effects of RPM should be considered in some cases. I think it's worth noting very briefly a historical record, and I promise I will be very brief on that, but it's worth saying that in the 80s, the Court of Justice of the European Union considered that RPM was a by-object infringement. In itself, by itself, it should be forbidden. Fixing prices, says the treaty, is contrary to the very goals of competition law, and therefore any vertical agreement fixing prices would be forbidden. However, the case law evolved, and of course, considering also the changes in the US, even if we didn't change the rules as such, I would say that authorities would somehow accept the rationale of the leaking case in the way they acted and in the way they enforced these provisions. And actually, during the 2000s, the first decade of the 2000s, there were hardly any case of the European Commission on RPM. There was one in 2003 on Yamaha, and then until 2018, there were no other cases finding companies for RPM. The gas decision and the electronic equipment decisions finding Pioneer, Asus, etc., with some fines. As regards national authorities, you could see also that this leaking rationale permeated in their rationale. Some authorities just said, well, I understand this is a by object restriction, this is what the Court of Justice says, but this is not my priority. I don't think it's very important to preserve market dynamics, to prosecute RPM. And for example, some authorities, as the Netherlands authorities, said in so many words, this is not my priority. Of course, this does not mean I may pursue some RPM cases if the case is relevant, but this is not under my priorities. And in the Spanish case, for example, we also see a shift from a first moment at the beginning of the 2000s, where actually they were dismissing many RPM cases, saying, well, I will consider them basically de minimis. I don't see the impact in the market. I don't see myself devoting public resources to prosecute that, even if it's an RPM practice. But the effects in the market are not substantial. But you could see a shift by the late 2010s, probably due to e-commerce, and we will deal with that later, and this fear that RPM practices would allow suppliers to prohibit distributors from selling online, or would make it more difficult to distributors to sell online. So, however, many cases, even if prosecuted with this e-commerce scenario, many cases finished with settlement or some other sort of cooperation agreements with the parties involved, which is also striking, because if conceptually it's a by-object restriction, normally you wouldn't expect an agreement or a settlement in a by-object horizontal restriction, whereas in RPM cases you find it much more often. As regards other authorities, we don't have the time, but just to mention that there are other authorities that do seem to prioritize RPM, and that would be the case, for example, for Austria, for Germany, or for Belgium, which are much more active in RPM prosecution. And I'll stop there.
Thank you very much, Yolanda. No, very, very interesting information. Shifting then to New Zealand, I would be interested, Luke, to hear a little bit from, the approach from New Zealand, and I think taking from some of the points that Yolanda was mentioning, such as to which extent not only how it works there and how you treat, but also has there been a priority, to which extent the Legion case has affected or not, at least the overall discussion, even though we know the approaches are different, so please.
Thanks, Barbara. Kia ora, everybody. Thanks to Kaja for hosting this great event. It's wonderful to be here in Rio on the other side of the world with everybody. So I'll run through the New Zealand approach to resale price maintenance and then touch on some of the other points that you and Yolanda have made. So resale price maintenance is a per se offence in New Zealand under the Commerce Act. The offence has had effectively the same form since 1986 when the legislation came into force. And the structure and content of the offence is materially the same as the Australian legislation under what is now the Competition and Consumer Act 2010, which is why I asked Barbara to go first, so that I don't just have to repeat what Sharon says. She just has to repeat what I say. The New Zealand prohibition on RPM is very formalistic. It's a relatively long section of the legislation that really specifically sets out what constitutes practices of resale price maintenance. But when we're summing it up to businesses that we talk to, we really boil it down to two things. First, you need a specification of a price, and second, you need certain enforcing conduct around that specified price. And our legislation is quite permissive about what constitutes a specified price. It excludes maximum prices, which is consistent with most other jurisdictions around the world. Maximum prices are still subject to the remaining prohibitions in the Commerce Act, including misuse of market power. We had a maximum RPM misuse of market power case in the late 1980s, which was unsuccessful. But all other types of specified prices are included, including minimum prices, set prices, so no ability for the reseller to determine the price, and then prices set by things like formulas or by reference, and so even you can't price lower than the seller down the road would count as a specified price.
Not even maximum prices, just taking from what Yolanda was saying, right?
Yeah, so maximum prices are excluded, but any other specification of a price is included. And then there's a range of forms of enforcing conduct that are included within the prohibition. Of course, entering or offering to enter into an agreement with an RPM clause is prohibited, but so are things like a manufacturer making it known to a reseller that they won't supply them unless they agree to RPM, even if there's no agreement, and even if no formal agreement is offered. Other conduct, including inducing or attempting to induce a party to enter an RPM agreement, is prohibited. And a more complex prohibition on withholding goods is set out in the Act, which covers situations where parties have a supplier relationship and there's a specified price is communicated, but for whatever reason it isn't set out in a formal agreement, but the manufacturer enforces the specified price anyway by cutting the reseller off or by materially changing the terms on which they supply them because of non-compliance with the specified price. I went back through the relatively limited case law, which I'll talk about in a second, and also determined that one of the points of discussion in the RPM literature, especially in Legion, is minimum advertised price schemes, which is set out in the Colgate case from the US Supreme Court. It was an interesting loophole in the American per se rule where a supplier couldn't specify a minimum resale price, but they could specify a minimum price at which goods could be advertised. There's a specific exception in the New Zealand legislation that prohibits that practice as well. So no getting around that. So like I said before, RPM is a per se offence in New Zealand and it's subject to the same pecuniary penalties provisions as cartels and misuse of market power. But the Commission's enforcement of the RPM prohibition has changed over time. Enforcement of the prohibition was much more active in the early years. Most of the cases that have actually gone to civil enforcement were in the early to mid-1990s. Although we've undertaken investigation since this time, the Commission hasn't taken an RPM case to civil enforcement since 2006. The largest fine the Commission has successfully secured for an RPM breach was $250,000 against Toyota in 1997. Compare that to the largest fine we've secured under misuse of market power, which was $12 million against the incumbent telco monopoly Telecom in 2012. So that's quite significantly less. And to my knowledge, there have been only approximately 8 civil pecuniary penalties ever imposed for RPM in New Zealand since 1986. So internally within the Commission, we've had for quite some time some discretion in our enforcement of the RPM prohibition. Sometime after the Legion case, the Commission internally developed a policy about when we would prioritise RPM cases for enforcement. We had that policy internally for some time, but we didn't externally communicate it formally, for example, in guidance, although I believe we talked about it at conferences like this. We formalised and published that policy in 2022 in a revision to our RPM guidelines. So the Commission sets out in our guidelines the situations in which we prioritise RPM for investigation, and it's similar to the points that Yolanda has made before. The situations where we'll prioritise RPM are where parties to the arrangement have market power, whether it's individual market power or joint market power. Second, if the RPM is broad or common across an industry or sector, that is, if there are multiple parties using RPM arrangements. Third, and linked to that, if the RPM is used or could be used to facilitate collusion, including tacit collusion. And then finally, where there's pressure from resellers upwards to manufacturers to impose RPM, and that's particularly the case where the resellers might have market power downstream. Given all of that, though, the Commission does still have a discretion to investigate RPM where it falls outside of those guidelines. And some of the situations where we choose to do so include where the magnitude of commerce affected is very large, even if the effect on competition may not be great. Second, if the parties to the RPM are engaging in rigorous monitoring of pricing, including using pricing comparison websites. And then thirdly, in cases where, even if the magnitude of commerce is small, where the pro-competitive potential effects of the RPM are very weak, which might include situations like cheap or fast-moving consumer goods that are very well known to consumers. And I think we'll talk more a little bit later about some of these potential pro-competitive effects of RPM. All of that said, though, we don't just ignore RPM cases that don't fit those priority guidelines. RPM is still a per se offence, and it would be remiss of the Commission to completely ignore a per se offence in our Commerce Act. Instead, we have for some time taken a more informal approach to use what we call IPTT letters, which stands for Information Passed to Trader. And they're a form of letter that attempts to educate and inform businesses about the scope of the law. We also use them quite commonly in our consumer law enforcement practice for minor breaches of the fair trading legislation. These letters could be quite general if we have just received broad complaints, or they can be very specific if we have received specific complaints. We've sent IPTT letters to parties spelling out terms of specific contracts that we consider breach the RPM prohibition. And our quote-unquote strike rate with IPTT letters and RPM has been quite good recently. The firms that we've sent these letters to in the RPM context have responded. They've voluntarily engaged with the Commission about their conduct. Some firms have voluntarily changed their conduct with or without discussion with us. And some firms have provided evidence to us that they are not in fact engaging in RPM. For example, if they have a formal agency arrangement that might from the outside look like RPM, but there is no resell relationship. Finally, in thinking about the pro-competitive effects of RPM, unlike many other regulators around the world, the Commission and the ACCC have a formal authorisation function where parties who want to engage in conduct that might breach any of the sections of the Commerce Act we enforce, which include misuse of market power, it includes resale price maintenance, and now it also includes the cartel prohibition, they can apply to us for authorisation. And so when we receive an authorisation application, we assess the conduct and we assess its competitive effects. And if we don't think the conduct substantially lessens competition in breach of one of the prohibitions, then we can grant authorisation. But we also have a broader public benefit standard. And if we think that the net public benefits of the conduct outweigh the net detriments, even though there might be a substantial lessening of competition, we can grant authorisation. And the factors that we can consider in this authorisation, the net public benefit test, are quite broad. We've included things like environmental benefits that go outside of competition between the parties. And we have a similar test, authorisation test in mergers, and we once considered the importance of media plurality to a functioning democracy in a merger authorisation. So it's quite a broad test. Unfortunately, we've only had one application for RPM authorisation since 1986, so limited case law on this. It was an application by HP, the computer company, to impose RPM on its New Zealand distributor on its online retail site. A decision was published. We considered there were no material detriments to this RPM, and there weren't really any material quantifiable benefits either, but there were some customer service benefits against the counterfactual HP set out, which was that it would simply not sell its products online at all in New Zealand. And so when we weighed up the public benefits of HP having an online store versus not having an online store, we thought that the balance tipped in favour of granting the authorisation. And it's very similar to a similar case in Australia. And then finally, taking up quite a bit of time here, but something that we don't have in New Zealand that is contained in the Australian equivalent legislation, which I'd love Sharon to talk about, is an informal notification regime where parties can effectively apply for informal clearance for RPM behaviour. We don't have that, and at the moment there are no plans to change the legislation, but it is certainly an interesting idea.
Thank you very much. So, a number of interesting points for us to revisit. Shall maybe taking from what Luke just presented, if you could compare the Australian system, and I was interested in this last part that Luke mentioned as well about this authorization.
Thank you, Barbara. In Australia, as Lucas mentioned, RPM is also a per se breach. It's the only per se provision in our competition law. In 2015, a review of Australia's competition policy considered whether RPM should continue to be a per se breach or should be subject to a competition test. And the review didn't see a sufficient case for changing the prohibition on RPM from per se to competition, to a competition-based test, I should say. But the review did recommend that RPM conduct should be able to be exempted under a notification process, which is what Luke just mentioned. So Luke described authorisation. Authorisation is a process where a party makes an application for exemption, and the ACCC then makes a decision whether to grant the exemption or not. Notification is a different process. A party lodges a notification, an exemption commences automatically unless the ACCC sort of moves quickly to stop it. So it's sort of a reverse process to authorisation. So that the new RPM notification process has been utilised, not terribly much, but it is used by businesses from time to time. But while there is both authorisation and notification now available for RPM conduct, we continue to investigate RPM that isn't authorised or notified. And in fact, I almost go so far to say that Australia is in a bit of an RPM renaissance at the moment. So in 2023, the ACCC obtained a record penalty in an RPM case. We got a penalty of $15 million. The previous penalty for RPM that we obtained was $350,000, so that just gives you an indication of how significant that $15 million penalty was. It was against a power tool supplier called Tektronix. Tektronix admitted to engaging in RPM conduct in relation to Milwaukee branded products, including power tools, hand tools and accessories. The ACCC submitted to the court that this level of penalty was appropriate given the seriousness, duration and extent of Tektronix's conduct. Tektronix admitted that it had entered into 97 agreements with retailers and dealers which restricted the sale of Milwaukee products below a specified minimum price. So that was sort of the price element that Luke talked about. That's common between Australia and New Zealand's RPM laws. And Tektronix also admitted it had enforced the restrictive RPM provisions in its contracts 29 times, including by issuing warnings to dealers who didn't comply with the RPM requirement that Tektronix had imposed, and Tektronix also withdrew supply from 2 dealers. So that withdrawal of supply we consider as a real aggravating factor in RPM cases. And then since the Tektronix case, we've actually accepted 4 court enforceable undertakings for RPM conduct. We have RPM matters in our pipeline. I sort of referred to our pipeline yesterday. It includes RPM matters. And yeah, I'll talk more about enforcement of RPM a bit later. Yeah, thank you.
Great. Thank you very much. I think that maybe shifting from this overall scenario, we could talk a little bit more in details about the very concept of rule of reason or per se approach, just because this brings a little bit of theoretical questions that would lead to what, and this connects a lot also with other panels talking about evidence that need to be produced, approaches, and other things that were generally discussed in relation to other conducts. So maybe going back to Europe in this context, Yolanda, If you could talk a little bit more about what it means to be treated as a by the object conduct at the end of the day, and maybe think a little bit about how this would relate to clarity to some extent of the enforcement, and at the end of the day, maybe bring in as, even though I was an enforcer in the past, but thinking as an NGA, I mean, of course, predictability, clarity, and everything is quite important as well for business. So bringing the pros and cons at the end of the day of adopting one another approach is something that could make a lot of sense. So if you could comment a little bit of how this has been addressed, theories of harm brought and level of evidence, I mean, that would be very interesting.
Sure, thanks. Well, as I said in my prior intervention, for many years, RPM was being treated in Europe as a by-object infringement, almost by definition, by the only gathering of the agreement itself. The Court of Justice had said this is in itself a restriction incompatible with Article 101 or the equivalent at that time. First thing that I have to say is that using this terminology, by object, by effect, is not to be equated directly to the per se and rule of reason approach that is used in other jurisdictions. Basically, because if I understand it correctly, when one conduct is prohibited per se, there's no justification possible. Whereas in Europe, where a conduct is a by-object restriction, at least in theory, it may be justified if the conditions of Article 101.3 are complied with. So there could be a justification even for a by-object restriction. That's and it's a new case of a distributor in the ORECA, in the on-trade channel. And, well, actually, this first case afterwards led to a whole hub-and-spoke investigation, and actually a much bigger case, showing probably one of the most harmful effects of RPM, which might be collusion, as we all know. And in that case, in 2023, the Court of Justice kind of amended its jurisprudence, its case law from the 80s, saying, well, being a by-object restriction cannot be an automatic conclusion for any agreement, and also for RPM. So even if we have an RPM agreement, and we've seen this clause, we need to conduct a certain analysis. We need to examine the agreement itself, we need to examine the aims of the agreement, and we need to examine, and this is the most important part, the economic and legal context in which it takes place. So it was not that an important statement in terms of formal theory for competition lawyers, because this is what it has already been said for horizontal agreement, but RPM was the odd one out. Somehow this logic was not being applied to this vertical restraint, and in 2023 the Court of Justice clarified that this logic was also applicable to RPM. So even if today an RPM agreement can be a by-object agreement, there's a need to demonstrate in the legal context, and therefore examining the nature of the products that are being sold, and also the structure of the market and the market shares of the party, if that restriction has as its object the restriction of competition. And if the conclusion is no, then we will have to examine effects. That to say, it's not that we no longer accept a by-object rationale for RPM in Europe. That can be the case, but after a certain examination that is at odds with the automatism that was being applied before. It's probably soon to see the effect of this case law in national authorities, but somehow this reflection already reflects and demonstrates this kind of different approach to RPM that I mentioned earlier from different authorities that were finishing RPM cases with settlements or with agreements with the infringers, or some authorities even saying, this is not my priority, I'm not going to pursue this. In the end, I think, and just to connect with your last question, I think that probably both enforcers and practitioners and undertakings will agree in theoretical terms that RPM may have pro-competitive effects and it may have anti-competitive effects. There's kind of a consensus on that. The question is, how do I know in which cases the anti-competitive effects are more probable and therefore it's worth it for an authority to allocate resources to pursue that, to try to investigate that, and how do I know in which cases these anti-competitive effects are not probable or are really so minor that still it doesn't make sense to allocate resources to that. In terms of previsibility and legal certainty, well, an RPM restriction by object or per se, it's very predictable. I mean, you have the prohibition, you cannot do that. It's very easy for an undertaking to know this is prohibited. But still, it leaves, it probably leads to unfair situations where, well, the most common pro-competitive effect, as you know, is the prevention of free riding. And I'll go deeper into that with the e-commerce question later. But there might be cases where RPM might be justified. And then probably this balance, this rule of reason, or this nuance that the Court of Justice has introduced in the automatic definition of a by-object restriction makes sense, yes.
That's interesting. I think at the end, I like the way you put, Yolanda, because at the end we are talking about, I mean, what are the resources that the authorities would be putting or the efforts that the authorities would be putting, but this comes to a large extent from the legislator when they really, put in one place or another. And in fact, this explanation about how the by-object assessment happens, the burden is still on the party to find the justification vis-a-vis a situation where you're going to have a rule of reason where it would be up to the authority to prove the anti-competitive effect at the end of the day. So it's still, if we were to think about, it seems to be more anti-competitive than pro-competitive, and that's why it's allocated on one way or another. And if we maybe shift now to Australia, and you comment here, Sharon, a bit, and just to bring the perspectives from South Africa, we heard from our South African colleagues that participated on the prep sessions that, in fact, there is really a per se approach. And as far as I understood, and I do not want to be, and if we have anyone on the audience here, when I comment, feel free to, but apparently in South Africa is not even the approach that we heard from New Zealand and Australia. It seems to be really pretty much a very straightforward approach in terms of not accepting RPM at all. And so again, there is a lot of the scope of the legislator and the scope of the authorities at the end on how to frame, because we know how burdensome it can be to go through.
But we tend to apply a competition test to those cases to try and prioritise what we will pursue or not pursue. And it sounds very similar to the approach that is taken in New Zealand. We look for RPM matters where, as I said, there might be sort of the aggravating factor of supply being withdrawn. We look for RPM in markets where we think there are particular market conditions that might mean the RPM has more of an anti-competitive effect in that market. We also think about RPM complaints sort of relative to each other. So even at the moment, we are almost batch processing RPM matters and choosing from, we might have 6 on our books at the one time and trying to assess which one of those is the most, causes the most harm to competition, and sort of will then take that one forward as an investigation. We also think about whether RPM even if we select something to progress further as an investigation, we will have a think about whether are we working towards a court outcome, are we working towards perhaps a court enforceable undertaking instead, or is it just going to be, you know, a warning letter to the trader? So those are things we take into account. We also, if we see an industry where we are getting a lot of contacts about RPM conduct, we are starting to reach out to the industry, and a lot of industries have industry associations. So we reach out to the industry association and let them know that we've sort of had some concerns about their industry raised with us, and we're starting to do presentations to industry associations just explaining what RPM is and that it's unlawful in Australia, and this, you know, these are the types of arrangements that fall under our RPM provision. So that's sort of the work that we're doing, yeah.
Good. What about New Zealand? What are the similarities, and if there are any differences that you'd like to comment?
Yeah, so look, yeah, I covered earlier our approach to enforcement of the RPM prohibition, and, you know, I think our published approach to enforcement of RPM acknowledges that I think it's fairly uncontroversial that RPM can be anti-competitive, it can be pro-competitive, and it can probably be fairly neutral in lots of cases, like in the authorisation case I mentioned earlier, where the benefits were, you know, relatively unquantifiable. And in preparation for this panel, I reread the US Supreme Court's decision in Legion, and in the decision, the majority and the minority both discussed that you know, antitrust law generally reserves per se rules for the forms of conduct that are overwhelmingly negative for consumer welfare. Of course, the majority-minority disagree on whether RPM is overwhelmingly negative for consumer welfare, but I think most agencies have taken the position that, at least in some situations, it can be pro-competitive, unlike cartel conduct. But as I delved a little bit more deeply into that decision, I did want to highlight something, a disagreement between the majority and the minority in Legion, which sort of just raised questions in my mind about where we are in the literature and the research on RPM. So in the majority case, in the majority judgment, Justice Kennedy talked about the research into RPM and about how there was very little evidence in RPM cases of collusion having been undertaken, and therefore the analogy between RPM and collusion was relatively weak. But then Justice Breyer, in his minority judgment, raises a pretty good point that in most of the RPM cases, there was no alleged collusion because RPM was a per se offence, and so there was no reason for the authority, whether it was a state or federal authority or a private action, there was no reason for them to research whether there was or was not collusion. And it would be interesting to see where the literature is at now and whether there's any new research on that, because, as I mentioned before, one of the key ways that RPM can be anti-competitive is it can act as a form of tacit collusion, effectively a hub and spoke cartel, either between retailers or manufacturers to control price. And, you know, I think when we're seeing those types of outcomes, we can probably all agree that that's pretty overwhelmingly negative for consumer welfare, where you're facilitating a cartel type arrangement between a set of interlocking vertical agreements. As I mentioned before, in New Zealand we've almost split the difference a little bit between per se and rule of reason by taking a pretty clear and published scales of enforcement approach. And so, you know, I think reflecting on it, the Commission accepts that RPM is a per se offence, and it's the response to RPM that varies based on the severity of the case rather than whether we treat it as a problem or not. But I wanted to highlight something that the South African Commission, I'm sure, would have highlighted in their interventions had they been able to be here. A case from the South African Competition Tribunal, in an RPM case from a couple of years ago. I'm not a South African practitioner, so I might get a little bit of this wrong, but it was a case against an appliance manufacturer called SMEG, where the Commission in South Africa reached an agreement with SMEG, a commitment and a penalty. And in its submission to the tribunal, the South African Commission made the point that I think we would all agree with, which was that well, RPM has started to be treated differently by global regulators, and there has been a shift away from a per se approach and an acceptance that RPM can be at times pro-competitive, or at least not anti-competitive. And the Competition Tribunal was not accepting of that approach at all. Its view was that where you have a per se offence, you need to treat it like a per se offence, and any deviation from that, where you have a clear legislated offence, is something for the legislatures, for Parliament to deal with, not for the antitrust enforcer. So it is interesting that there is still a bit of divergence amongst agencies about whether or not it's appropriate to engage in a bit of enforcement discretion over RPM matters.
Thank you. Something that was mentioned earlier, and I think, Yolanda, maybe you could bring a perspective on that, and we had some panels on digital and e-commerce as well. I think this topic, the topic of RPM, as we heard, has been there for quite some time. Apparently, in a number of jurisdictions, hasn't been necessarily a hot topic, but in the context of e-commerce, this seems to have raised again new concerns, or has reheated old concerns in the context of digital. So maybe you would like to comment to which extent how RPM in digital marketplaces could affect competition, or which are the cases that are dealing with that, because it seems that a new perspective or a new dynamic has arisen in that context.
Yeah, I like the word you used. It's not that we have new problems with e-commerce, it's that past problems or old problems were reheated and were brought back to the discussion, right? And probably the dimension of the problem got much higher. Well, yes, on the one hand, relating to my comment earlier that there's this certain bias sometimes that when we deal with RPM cases, we tend to understand that it's the supplier imposing the price, which may happen many times. In some cases, it's not the case, and it's the distributor who has the power, or even both of them who agreed. I think that with e-commerce, it's quite evident that the dimension of some players acting sometimes as pure intermediaries, but some other times also as distributors, make them also a relevant player to take into account, and upon whom it's very difficult to impose anything. So that would be one first consideration. Another consideration is that with e-commerce, price monitoring has it's very easy. And it's very easy for a supplier to monitor all its distributors. It's very easy for platforms to see what other distributors are doing. And it's also very easy for competitors to check whether the price in a possibly collusive scenario is being respected. Also, on the other hand, the problem of free riding, the supposedly pro-competitive effect normally associated with RPM has become exponentially bigger, right? Because it's pretty easy for distributors to avoid the investments that brick and mortar would require and sell the products, taking advantage of the physical offline shops that a few distributors have. So, well, actually, and here I will come later with my society reflection on whether we want to keep or not offline distributors. And if we want, we must guarantee they're viable, right? So, and here our reflection comes with the new guidelines that the European Commission approved in 2022 on vertical restraints, where it certainly took a shift on the approach to e-commerce. In 2010, the past guidelines, the considerations were more for the promotion of e-commerce and not imposing limits on online sellings, whereas in 2022, in the revision of the guidelines, the Commission, while maintaining the prohibition on RPM, which is still a hardcore restriction, it said, well, it seems reasonable that a supplier may give some reward to offline distributors that are investing and promoting some kind of services that you wouldn't have offline. And actually there's a clearly new instrument, or at least a new tool that we can use and undertakings can use, which is the so-called dual pricing. Now companies are allowed to give different selling prices to distributors that are mostly operating online than to distributors that are mostly operating offline. And that's a kind of recognition that offline distributors are investing, and we want to protect those investments for the benefit of consumers, right? So, well, when putting that into practice, and it's been only 3 years since the revision of the guidelines, what I can tell you from practice, it's extremely difficult for undertakings to put in practice these dual pricing or multiple pricing systems. In theory, you can put that in a contract, but then how do you prove how many sales are made online and how many sales are offline? You normally don't have pure online distributors and pure offline distributors. You may have many of them that are hybrid, that are offline and online. How do you check? Do they have the incentives to give you the information on whether they are selling online or offline? If the supplier closely monitors what the distributors are doing, yes, price monitoring is not in itself a restraint, but it may be regarded suspiciously from competition authorities. What are you checking so much? Are you checking the resale price that your distributor is applying? So it's really difficult to apply this tool in practice, and I have no solution. I'm not coming here with the formula. I don't know what is the solution, but probably we need a reflection on whether we want to preserve these offline models and whether RPM, in some cases, maybe not in all of them, could help preserve these offline models that provide those pre-sale services, that provide a different user experience, etc., that we all, that are valuable for us as consumers.
Yeah, I think, again, going back to this whole digital discussion, when we look, we will see to which extent, I mean, RPM to some extent could even be seen as an innovation stimulating when you look at different channels, and on the other hand, if there are more risks for enforcers, or if it makes it harder for them to, at the end of the day, identify when the conducts are pro or anti-competitive, because I think we discussed that this is hard on the real world, if I could say, even though digital now is real too, but it's, we indeed have these challenges. So maybe even from an enforcer perspective, Luke would like to comment a little bit of, again, how can regulators address the risks of online RPM practices? Is there a difference on how to treat them online and offline, or how are you looking to that? And trying not to lose, and trying not to lose the potential positive effect that might come out from this in the online world.
Look, I mean, none of the three of us have done a deep dive into the pro and anti-competitive effects of RPM yet, but Yolanda touched on the classic free rider argument and set out, you know, one of the key reasons why RPM can be pro-competitive insofar as that it incentivizes increased pre- and post-sale service in bricks and mortar outlets. To take a slightly contrasting view to what Yolanda said, though, one of the considerations about the free rider argument in the age of e-commerce is that, well, consumer behaviour is changing, and we did a little bit of thinking about this several years ago, and you know, maybe it's the case now that consumer decision-making behaviour is changing. It's just as common now, if you think about last time you bought a relatively high value product, that you might do research online. You might go onto YouTube and watch a product review, or go onto a blog, or go onto a forum and discuss these things online. And we don't have answers to this question, but what's the different consumer experience between watching several video reviews on YouTube of a television or a stereo versus going down to the local electronics supply store and asking a staff member who may or may not know anything about the product about it. We looked online, and the use of price comparison websites as well has been massively expanding in New Zealand. There was a figure that approximately 20% of New Zealanders used price comparison websites back in 2018, and I'd expect that number to be much higher now. All of this might actually change the relative value that consumers attach to pre- and post-sale service, at least in some industries. There will surely be some industries where that is incredibly important and a really important pro-competitive justification for imposing RPM. But there might be some goods that generations ago we attached a lot of value to that pre- and post-sale service. Now that might have fallen away, and I think that's something that regulators need to think through as they're considering RPM cases in lots of different industries, and there might be space to do some research there. Other digital-related matters, I think, as Yolanda mentioned, price comparison websites have massively exploded in popularity. They're used by consumers, but they're also used by suppliers to check on what their resellers are doing. The massive expansion in the use of price comparison websites and algorithms that track pricing mean that manufacturers might not need to impose RPM on as many downstream players as they previously did. It might be sufficient to impose RPM on one or two of the major players and watch as price comparison websites and the use of algorithms by retailers see all of the prices fall into line. And in that respect, you might have the same outcome as a hub and spoke type collusion arrangement with only one or two RPM agreements with retailers. And so that's an interesting intersection between sort of horizontal and vertical effects of RPM. And finally, one other point to consider, which also relates more to horizontal, is the expansion of the online sales channel has led to some suppliers starting to sell themselves into markets where they might not otherwise have. New Zealand is a relatively distant economy, it's a small economy. In generations gone by, we had mum and dad electronics stores who are licensed agents for various big companies. And now you'll still have electronic stores, but you'll also have parties selling themselves directly into New Zealand consumers. And so to what extent where manufacturers are selling direct to consumers, including online, and their resellers are selling directly to consumers, including online, to what extent are these parties actually competitors? And arrangements between them might be better characterised as horizontal arrangements. I'm not on the cartels team. New Zealand has a vertical supply exemption for cartel conduct to cover situations like this, but it doesn't cover situations where the purpose of the arrangement is to substantially lessen competition, and that might be becoming more common now. But again, that's deviating a bit away from unilateral conduct.
In Australia, I mentioned the 2015 review of our competition policy, which did actually note the potential for RPM to become more commonplace in the digital economy 10 years ago, so I guess that's happening. And in fact, eBay made a submission to that review stating that around 1/4 of the sellers on eBay are instructed by their suppliers to sell at the recommended retail price. I think in terms of the ACCC's enforcement approach, it hasn't changed. So we are still conducting the same type of assessment and analysis that we did sort of pre-digital revolution, which is that sort of what is the real impact on a market from the conduct. But as Yolanda sort of flagged, we have observed suppliers with multiple distribution channels, so both online and bricks and mortar channels, caring more about RPM in their online channels and really not caring very much about pricing in their bricks and mortar channels. So that is something that we I guess that's just an observation we've made. I'm not sure that online distribution makes our job any harder in terms of the assessment, to the extent that pricing information is available online to competitors or other suppliers. It's also more available to the ACCC, so it's sort of a data-rich environment, which can be helpful. So yeah.
Thank you. Well, I think just to conclude, and we're going to use a little, our panel was, the idea was to finish at 4:45, but we started a few late. So just to conclude and hear from our enforcers here, I think it would be interesting to get a little bit from you on what are the challenges of being seated where you are, because at the end of the day, we are in a comfortable situation here discussing theoretically, but whenever you have a case in front of you, how would you, at the end, deal with that? What are the types of challenges? To which extent, and maybe comment a bit on to which extent an RPM can be seen as a stepping stone on a more consolidated behavior, which indicators would, I mean, which are the cases that would lead to risks of more possible cartel or coordinated cases at the end of the day. And very quickly to comment, because in Brazil, even though we do have, I would say, if you ask the authority, I think they're going to answer that we take the rule of reason type of approach. But when it comes to the tables of prices established by associations that defines the prices to be charged by physicians or to be charged, well, they're quite spread out. We have Commissioner Gustavo here, and I think those are kind of treated as a fast-track cases as illegal per se at the end of the day. So whenever you have situations that are not really coming from a company where you could have some discussion on whether there is logic to protect interbrand competition or not, when it comes to tables of associations or unions, it's quite a straightforward approach. And I would say, just to go back to the point that Yolanda mentioned at the beginning, it's not even when CAGI announces the numbers of investigations, they mention the cartel cases, the unilateral conduct cases, and the influence to uniform conduct. That is kind of a third type of agreement. So at the end of the day, it's treated not really on either unilateral or coordinated, just going back to the point of she brought. But again, just looking for, again, if we're looking to those tables, it might be an easy approach. If you have a purely RPM case, the challenge is harder. So how would you look at that in New Zealand, for instance?
Yeah, thanks, Barbara. Look, the point about the unions or associations issuing pricing guidance is, Sharon and I were discussing this, more likely in our cases to be treated as cartel conduct. There's a provision in our Act where actions by associations with members are deemed to be actions of the members in certain situations. We recently had a situation where we issued a compliance advice letter publicly to an association. It wasn't about restricting members' pricing, but it was about restricting certain medical professionals' offering of training to certain parties who might compete with them. And we treated that not as a cartel matter, but as an anti-competitive agreements matter. And we saw the recommendation issued by the industry association as one that was effectively issued to and for its members. Some of the other challenges in enforcing the RPM prohibition, even with the discretionary approach that I talked about before, some matters are things like, well, when we're thinking about the pro-competitive benefits of potential RPM, how do we measure that? You know, what's the counterfactual? What are we comparing this against? Where parties claim that RPM is necessary to protect innovation or prevent free riding, I mean, what evidence do we need to consider that? And from our perspective as an agency with the per se rule, what evidence do parties actually need to provide us to prove this to us? Sometimes it's very hard to prove a negative, but it conceptually perhaps quite difficult to show increased innovation from the use of RPM or measure increased consumer satisfaction from pre and post sale service in bricks and mortar stores. and that's something that we haven't directly addressed yet, but it certainly would make the application of our guidelines more difficult. And then finally, I touched on the cartel risks before. I think determining between anti-competitive and pro-competitive RPM does touch on that horizontal element. The South African Commission shared with us an anonymised example of a case in which they were investigating a party for resale price maintenance, and that party denied that it was engaging in RPM, but then applied for cartel leniency and said that its RPM agreements were actually just its attempt to engage in cartel conduct, and therefore, since it was first in the door, it could get immunity. You can't get immunity for RPM, but you could for cartel conduct. The South African Commission did not accept those arguments, but how we accurately characterise this conduct in context is really, really important. And I think we all recognise that across jurisdictions, even where you have a per se approach, you do still need to look at the conduct in context. Not just what its effects on competition are, but also what its purpose is. I think a regulator would be remiss to undertake an RPM investigation, obtain a copy of a contract, see that it's signed, and launch a civil claim against the party without exploring what the justifications for that conduct were, what its purpose was, and how it impacted competition, even if that regulator doesn't need to prove a substantial lessening of competition. Because you've got limited resources as regulators. We know this, we have to prioritise cases every day, and if you're not making those judgments of how this case fits in the broader context of what us as a regulator are putting our limited resources into, then yeah, that's not an optimal outcome.
Yeah, no, and indeed you mentioned this point about, whether this would be treated close to cartel or not. Something we discussed on the prep session also had to do, and we would not get there, but we discussed how this can connect with hub and spoke type of conduct, because at the end of the day there could be some connection there, not when it's a table sharing, but rather when you have a supplier establishing the price and what is the impact at the end of the day. But then maybe to conclude, Sharon, you want to make the last words.
Well, Luke's just said some great points that are applicable in Australia too, but I thought I'd just briefly mention RPM conduct that isn't documented. So we are sort of increasingly dealing with more sophisticated businesses that are documenting the arrangements that they enter into with their distributors, because they know that there might be an issue with the ACCC becoming a bit interested in what they're doing. So that presents challenges in terms of just proving what is happening. We are able to use compulsory notices to compel people for interviews with the ACCC. We are doing that. We also, in those circumstances, think about whether to make allegations against the individuals involved rather than just the businesses. So that's a way to sort of amp up our enforcement response to that more covert RPM arrangement. And as Luke mentioned, we always, in Australia, like New Zealand, we always give some thought to whether there's anything horizontal sort of spinning off a vertical RPM arrangement, or the potential for that to happen, which again might warrant sort of a enhanced enforcement response from the ACCC.
Thank you very much, Sharon. I don't know if you want to make a comment.
Well, just I mostly agree. I would say when there's indicia of collusion or where there's indicia of hub and spoke, I mean, some cases are pretty straightforward. I'm not saying they are easy to construe, but if you find evidence, as in the Portugal hub and spoke cartel, evidence that suppliers and retailers are using one another to pass information and to maintain the prices at a certain level, whether it leads to collusion at the supply level or it leads to collusion at the retail level. Of course, it's relevant for the fact of the case, but in the end, what I'm saying, it leads to a horizontal agreement, which is indeed a serious infringement has to be pursued. But I'm also thinking of some recent precedents from the French authority that find in 2024, last year, for RPM in the area of household appliances and electrical equipment, and the authority found evidence that the distributors agreed on RPM and actually asked for it, and they actually wanted to keep the market quiet. So if the evidence is there, there's no problem. What happens with the more tricky allegations, justifications, as Luke mentioned, with the free riding problem? How do you address that as enforcers, and how do we address that as private practitioners? It's really complicated. How do you show that the free riding rationale is behind the agreement? What do you need to prove? Do you need to prove that 1 or 2 online distributors were selling at unbeatable prices, and therefore offline distributors may be at risk? It's there where I think that we need this kind of rule of reason or presumptions, or however we want to call it, and a society decides, well, in certain cases, in certain markets where the market is very concentrated, where there is this risk of collusion, then I will devote resources, but otherwise it may not be worth it.
Yeah. Well, I want to then thank very much the very thoughtful and interesting provocations and points brought here. I think we need to resume here and to give you some time before dinner, but maybe you'd like to.
Thank you to all speakers for the presentation, and thank you very much. We had a very productive day. I would like to remind you that our workshop dinner will be served at 8 p.m. the hotel venue on the ground floor, and see you tomorrow at 9 a.m. with breakfast. Thank you very much. Enjoy.